Wait, please, Your Lordship.
Yes.
May I please, Your Lordship, my lord? Lordship, with the consent of the other side, I beg to mention item number 21 of the daily list, Lordship. In this matter, Lordship, we need further 3 weeks time to file our affidavit in reply, Lordship. Recently, the BTC has filed their affidavit, Lordship.
As paid for by the learned counsel for the petitioner, 2 weeks time is granted for filing reply affidavit. List again on so and so.
Deeply obliged.
Wait, please, Your Lordship. I'd like to mention item number 88 of the supplementary list.
Item number
Due 88.
88. Okay.
So I've taken due consent from the other side. If Mrs. R. Bora, the standing counsel for CBSE, she is not well. So may it be taken up on 3rd of February, Your Lordship.
Ms. R. Bora, learned standing counsel for CBSE, is said to be in this post on a claim made on his behalf, on her behalf, and not objected to by the other side. List again on
3rd of February.
3rd of February.
May I please, Your Lordship? Lordship, I'm praying for listing of a read petition in the motion column, Lordship. I have filed it on 19, Lordship. I'm challenging a transfer order, Lordship. On Friday, Lordship.
What is the urgency?
Urgency is that, Lordship, I am being pursued to join in the new school, Lordship.
So Friday is a holiday.
Can it be tomorrow, Lordship?
Tomorrow, I don't know. 28. Motion day 28.
28.
Yes, Wednesday.
With the consent of others, I beg to mention item number 87, supplementary motion matter. Last occasion, we were directed to file additional affidavit. Additional affidavit will be filed today itself. Let it come on 28, my lord, on motion day.
Okay. Mr.
And Sharma.
N. Sharma, learned counsel for the petitioner, submits that as directed by this court, additional affidavit is going to be filed within the course of the day. And he prays that the matter be posted on 28th.
Yes.
28, 2026. Considering the submission, let the matter be listed on 31.
May I, Lordship?
Yes.
Yes. Like mention item number 2, Lordship. Actually, we are supposed to file an additional affidavit, bringing some new relevant document, but some instructions are still awaited from the petitioner. So, Lordship may fix the matter after 2 weeks, Lordship.
Okay, on the prayer made by the learned counsel for the petitioner, who says that further instructions is being awaited from his client, matter stands adjourned. We will list it again on 13.
Obliged, Lordship.
May I please? So I am praying for listing of a case for motion on 28th this month.
What is the urgency?
Lordship, already instruction was sought for Lordship. Similar case is fixed on 28th.
All right.
May I please, Your Lordship? I beg to mention pending writ petition, Lordship.
Pending, you have to go to the registry. Make a request there to get it listed. All right.
May it please, Your Lordship. Your Lordship, with the consent of the other side, I beg to mention item 30. Lordship.
30.
30, Lordship. I'm appealing for BTC, Lordship.
You are appearing for BTC.
Lordship.
What do you want?
Lordship, an adjournment, Your Lordship. May it
Why?
be listed after 2 weeks.
Why? Why do you want adjournment?
So there's some difficulty and we have already taken consent from the petitioner's side.
BTC means respondent number. Your good name?
Lordship, NR Sharma.
Mr. N.R. Sharma, learned counsel, appearing for the BTC respondent, submits that due to some personal difficulties, the matter be adjourned. And that he has taken the consent of the other side as well. In view of above, list again also.
Obliged, Lordship.
May I please, Your Lordship?
Yes.
I beg to mention item number 24 for adjournment with the consent of the other side.
Item number
24, Your Lordship.
24. Yes. You're for the petitioner.
Yes, Your Lordship.
Why do you want adjournment?
The engaged counsel has some personal difficulty. B. Purkaster.
Who is that?
B. Purkaster.
Mr. B. Prakash, learned counsel for the petitioners. He said to have some personal difficulty. Will be appear before the court today. And on a plain on his behalf and not objected to by the other side. List again also.
Oblige, your lordship.
May I please, Your Lordship, I beg to mention for listing one admission matter, my lord. One admission matter,
Admission matter, please go to the registry and make a request there. Yes, please, your lord.
next week, my lord, any day.
Please inform the registry about your.
Your Lordship, this one is also for admission matter. my lord.
You may also do the same. Yes.
May please, your lordship, lordship, I beg to mention for listing an IA, deletion of names
Huh?
of the petition, lordship,
IA,
IA, lordship.
when did you file?
Lordship, I filed in the last month of December, lordship.
December.
Lordship. I for deletion of name, no,
I
on 13th,
understand.
lordship,
I understand. When did you file it? 13?
lordship,
13 December you filed.
lordship,
You have the filing number.
lordship. Then I had lordship,
Where's the filing number?
lordship,
Put it there.
lordship.
Give a date there.
30th, lordship, 30 of January
All right, 30
of
January.
life.
May I please, your lordship?
Yes,
Lordship, I beg to mention one WPC for withdrawal, lordship.
okay. You want to withdraw? Tomorrow?
Tomorrow, lordship.
Tomorrow?
May I please, your lordship. Lordship, I beg to mention item number 28. Today, my senior has some personal difficulty, lordship. Kindly the matter may be listed after 1 week, your lordship.
Who is your senior?
G. Boisseau.
Okay, Mr. G. Baisya, learned counsel for the petitioner is said to have some personal difficulties to appear before the court today. Not a mention made on his behalf, matter stands adjourned. We will list it again on so and so.
Lordship, it was filed on 9/1, lordship, not 30, lordship, 9/1,
Okay. 9-1.
9/1, lordship.
Okay.
Of life.
May I please, your lordship? The matter became infructuous, my lord. As per instruction of the petitioner, the matter may be withdrawn.
Yeah, what is your good name?
A.K. Hannan.
Mr. A.K. Hannan,
Yes, my lord.
learned counsel appearing on behalf of
M.J. Gadi.
Mr. M.J. Qadir, the appointed counsel for the petitioners, on instructions submits that matters become infructuous. Anyone else?
I am appearing for higher division, S class.
Mr. S. Das, learned counsel, appearing for the Higher Education Department, agrees to the site submission. In view of above,
Lordship, Council Mr. S. Both appears for respondent number 4, lordship. I'm appearing on behalf of him.
in view of above, the writ petition stands disposed of as infructuous. Then somewhere you add Mr.
S. Botakur.
S. Botakur, learned counsel appears for
Respondent number 4. Yes.
respond number 4. Okay.
Deeply obliged, ma'am.
Lordship, my lord, this is a compassionate appointment case, my lord. The petitioner case, my lord, was rejected by the district level committee.
What happened to the writ appeal?
Writ appeal, my lord, affirmed the single bench order, my lord.
When was it disposed?
My lord, 12.
Lordship, this is the gut. Of the writ appeal.
Is it relevant to this case?
Yes, my
Yes,
lord.
lordship. Only,
So-
only,
So what to do? We have to issue notice then?
My lord, it is a covered case, my lord, may dispose of it. my lord,
Covered
with-
case?
Yes. With same direction, my lord.
Covered by which judgment?
My lord, the single bench is judgment, my lord.
Where is that?
Dada. And this has been affirmed by the division bench.
yeah. Nine, yeah, nine, yeah. Paragraph number 22 and 23, lordship, of the judgment of the Honorable Division Bench, lordship,
17, para 17.
considering the application.
What is the clause 1 of the OM?
When that balance of 3 years remaining services required, lordship, as per this OM, lordship.
But that was interfered with by the single judge
That was set aside by the single bench, lordship.
and affirmed by the division bench.
Not by the division bench, but only lordship, but para number 22, lordship, the division bench judgment, lordship. While making such application before the concern of the private respondent, we may caution must not entertain any false hope, and concern authorities also shall consider the passage of time. Expect seriously while assessing the suitability of the private respondents for compassionate appointment, which would be most important factor in recommending the cases of the private respondents for compassionate appointment, which ultimately may not withstand the judicial scrutiny if such recommendation is made after long lapse of time since the death of deceased employees. With the aforesaid observation, we close the appeals with the hope that the statutory authority, while deciding the cases of the private shall appropriately apply the law with regard to the compassionate appointment. As per the Devabrata Tiwari case, Lordship, that is in para 20, Lordship.
So by this, what does it mean? It means that one should not have a false hope due to the long passage of time.
Yes.
Their cases will be entertained.
And the Lordship, that the judgment of the Honorable Supreme Court Lordship, that is Devabrata Tiwari case in page number 20, para 20, Lordship. That is also Lordship applicable, Lordship. While considering the case,
Debarata Tiwari,
yes, Lordship,
that will be applicable.
applicable, Lordship.
What is Debarata Tiwari?
Devabrata Tiwari is Lordship that after page para 20, Lordship, prohibits the compassionate appointment after long passage of time, Lordship. It is prohibits, Lordship.
But in the present
But
set
in
of
the-
cases,
Closing the chapter of private respondent would not be appropriate,
would
Lordship.
not be approved.
Only Lordship one fact, and that the PLC has considered again Lordship by placing the same Lordship on the, but it was not Lordship closed on the ground that there is a remaining balance period of 3 years, Lordship. On merit, Lordship, DLC will consider.
Yes.
This is for compassionate appointment or compassionate family pension?
Compassionate appointment.
Appointment.
Yes, Lordship.
The OM provided that the deceased government servant should have at least 3 years of remaining service.
Yes, Lordship. But
If that is that, they can be, the hairs can be considered for compassionate appointment. Single judge said that this is wrong, that aside.
Yes.
Division bench, that's again affirmed the judgment of the single
Judgment.
judge. So as on today,
Yes,
the case of the petitioner was rejected on that ground,
On that ground.
that there's no 3 years balance.
yes, Lordship.
Yes.
Where is the order?
My lord, it starts from page 16 and relevant part, my lord, page 17.
16.
Page 17 is the relevant part, my lord. Para 5.14.
5.14. Please read.
The district level committee Gwalpara scrutinized the proposal of Sri Rafiqul Islam, son of late Abdul Aziz Ahmed, ex-assistant teacher, Karipara ME Madrasa, for appointment on compassionate ground. The father of the applicant expired on 16/10/2016, and the applicant submitted the application for appointment on compassionate ground on 28/12/2016. The date of birth of the applicant is 30/12/1986. As per the report of the District Elementary Education Officer, Gwalpara, byte number so-and-so, dated so-and-so, the date of superannuation of late Abdul Aziz fails on 30/11/2018. Hence, it is clear that at the time of death of late Abdul Aziz Ahmed, he did not have the balance of minimum 3 years of service. Accordingly, the district level committee Gwalpara, on the basis of the guidelines issued by government in personnel so-and-so department so-and-so, OM number so-and-so dated 1/6/2015, decided to reject the proposal of Sri Rafiqul Islam, son of late Abdul Aziz Ahmed, for appointment on compassionate ground.
What is the date of this minutes?
1/6/2015.
No, that is the OM.
Yes, Lord.
The DLC minutes is dated 4/2/2022.
2020.
It was held on two dates, 4/2 and 7/4.
4/2 and 7/4. Yes, ma'am.
There are two dates, correct?
Yes, 16 by the way.
So can we dispose it off in that light?
Yes, Lord.
Please write, this matter was deferred due to pendency of writ appeal number 287 of 2023 filed by the state, challenging the decision of the coordinate bench of this court, which set aside the which clause is that?
Clause 1, my lord.
Clause 1
Clause 1 of
of the
memorandum dated
office
1/6.
memorandum dated
1/6/2015.
1/6/2015. Stop. Clause 1 provides that in order to be eligible to be considered for compassionate appointment, the deceased employee should have at least 3 years balance of service left before dying in harness. Stop. Next para. In the present case, the father, is it? Father of the petitioner
Father of the petitioner.
was born on 30/12/1986 and he
No,
died
my
in
lord.
harness.
This is the date of birth of the applicant. 86.
I'm sorry.
Father died on 6/10/2016.
Oh. But what is the date of the birth of your father?
Father's date of birth, my lord.
It's not there. In the instant case, the father of the petitioner expired on 16/10/2016.
Date of birth 16/11/1958
Yes.
in Annexure 1.
Yes,
And he was born on
16/11/1958.
16/11/1958. Stop such being the position. He did not have the balance period of, he did not have 3 years of balance service left at the time of death. And it is for this reason, and in view of the office memorandum dated 1/6/2015, that the case of the petitioner was rejected by the district level committee, Golpara, which held its meeting on 4/2/2022 and 7/4/2022, bracket annexure 5. Next para. As already stated herein above, the writ appeal was disposed of along with all other analogous writ appeals, white judgment and order dated
12/12/2020.
12/12/2025, affirming the decision of the learned single judge. Stop. In other words, the division bench found that clause 1 of the office memorandum to be constitutionally invalid as held by the learned single judge. So such being the case, and the decision being squarely applicable to the present case, the instant writ petition is disposed of by directing the respondent authorities concerned to place the case of the petitioner before the next, before whom?
District level committee,
Before the next district level committee,
Walpur.
Golpara. Nowadays, it's not constituted, isn't it?
Yes, Lord.
Is it being constituted? No.
Now it always that OM that Lordship that is over Lordship.
So what is to be done then? We'll have to direct for constitution then. Dispose of with the direction to the respondent authorities to,
Consider the case. To place the case before the DLC Lordship.
that I can say, but the thing is that nowadays you don't have DLC. Do you have DLC? Because you have the compassionate family scheme.
See, but as per Lordship, that OM that all the cases pending before the DLC that is considered by that OM.
Okay,
Lordship.
he's right, to place the case before the next DLC for consideration of his case. So it is made clear that if the DLC is not constituted, the same be constituted by the respondent authorities to carry out the above direction. It is also made clear that the case of the petitioner shall not be rejected on account of the late government servant not having balanced period of 3 years of service, in view of the decisions which has been rendered by the coordinate bench of this court and upheld by the Writ Appellate Court. So such an exercise as directed herein above be carried out as expeditious as possible and preferably within a period of
2 months.
6 weeks from today.
2 months. Because Lordship, the education department has forwarded the matter to the DLC.
All right, 2 months. Then 2 months from the date of receipt of a certified copy of this order. Please furnish. They'll do that.
And Lordship appropriately apply the law, Lordship, when the considering the case, Lordship, as per judgment.
That
of-
is always there. That is always there.
Is there.
Okay.
One more line. In disposing of the instant writ petition, Ms. D.D. Burman, learned senior government advocate, has also been heard.
Obliged, sir.
Please, Lordship. Can you period the order dated 18/12, my lord? This honorable court directed the my learned friend to receive instruction, my lord.
And Lordship, we have sent the affidavit for vetting, Lordship, but after 1 week. Lordship. That is-
Date is 17/12.
My lord.
You said 18/12.
My lord, 8/12, my lord, initial order, my lord.
8/12 is there, no doubt.
My lord.
Then 17/12.
17/12, my lord.
So let her file the affidavit.
My lord.
Ms. D.D. Burman, learned senior government advocate, submits that the affidavit in opposition has been set for vetting, and she prays for a week's time. And therefore, she prays for a week's time to file the same. In view of above list again also.
Obliged.
May I please your lordship?
Hmm.
Lordship, in this contempt petition, operative person is page 32, annexure 6. And para 7.
32 is not operative portion.
No, it's
This is the beginning.
beginning, yes, your lordship, judgment and order dated 20/2/2025, and operative portion is at 39. Para 7.
Heard, Mr.
S.K. Lahon. S.K. Lahon.
S.K. Lahan, learned counsel for the petitioner, who submits that the order dated 20/22/2025 passed by this court in WPC number 6993 of 2024 has not been complied with. by the respondents, despite a copy of the same having been furnished to them. Next para, issue notice returnable by 4 weeks. Steps be taken for service of notice upon the respondents by registered post within 3 days.
That's a list.
Yes,
My lord, order of this honorable court is at page 8 and relevant lordship page 15, para 14 and 15. There is a direction to release the area salary of the petitioner. Para 14 and 15.
Art Mr. M. Khan, learned counsel for the petitioner, submits that the order dated 2/9/2025 passed by this court has not been complied with by the respondents, despite a copy of the same having been furnished to them. The expiration notice returnable by 4 weeks. Steps be taken for service of notice to respondents by speed post within 3 days. I think we should give a date, a list again also. The other one also, in both cases. List again on 25.
May I please?
Yes, Mr. Payat.
My lord, what happened this case, my lord, we are the principal and the of the Silapatha College and the governing body of the Silapatha College. My lord, here what happened in 2020, my lord, there was an advertisement for, my lord, selection of the post of assistant teacher, Assamese department. One lady was, my lord, selected at that moment, but her, my lord, but her selection was not proper because she could not submitted some documents thereafter, my lord. Then that advertisement was cancelled. But my learned friends, my lord client, she has filed a writ petition before this honorable court, and accordingly, this honorable court directed back to my lord, give a conclusion to the my lord selection process. And another advertisement was issued thereafter, my lord. That's why she silenced. Accordingly, my lord, the governing body again, the selection committee again, my lord, sat together and selected another person, one name called Brajen Sharma, my lord. Then she again silenced that, my lord. Then this honorable court passed an order, directed, my lord, the parties to approach before the director, my lord. That is page 42 is the, my lord, direction of this honorable court in that case, my lord. Page 42, my lord. That was the last direction because the process was not complete. The director did not give any approval. So she was allowed to file a representation before the director. And director was directed to give any conclusion, final appointment order. Page 42, last part, my lord. That was the direction, man.
Yes.
But what the director did, my lord, in the next page, page 43, director passed a speaking order on 20th of June 2023. My lord, this speaking order was also silenced by my lord, the same, my lord, earlier, my learned friends. Then, in that case, my lord, this honorable court said, because there was allegation, my lord, that the OSD was given authority to check the numbers, marks of the candidates. So he has the, accordingly, my lord, that as direction was given the director to pass an appropriate order, speaking order, giving conclusion that he may pass an appointment order after seeing the ballot, hearing the parties. But OSD, as OSD, my lord, check the marks. So he did not, the director did not comply the order of this honorable court. Accordingly, this honorable court said, my lord, in another, the next piece 44 order, then no, director has committed a wrong because that the direction was to pass the order by the director only. Pass the order by the director only, not by the OSD, my lord. So he cannot, the OSD
So,
cannot be given the authority to
Who has
look up
passed the order? OSD?
Yes, no, OSD didn't pass the order, my lord.
Then?
OSD, my lord, check the marks and accordingly, my lord, on his recommendation, director passed that order that, my lord, the marks calculation was wrong. So it is properly, my lord,
Where is it indicated in the order?
my lord, your lordship will be page 50, my lord.
No, page 43. 43 has been challenged, is it?
Yes, 43 was challenged. Page 50,
Because 43 was passed on the recommendation made by the OSD.
yes, that is the third para, my lord. Fourth para was there. However, publication of the third para, hearing the publication of the considered the project
By the OSD. Correct,
Yes.
I've seen it.
Yes,
So this was again set aside.
this was again set aside. By my lord, your lordship will page 50 is the, my lord, page 50 para 8 was the from para 7 onwards. It is to be made clear that the order dated so and so past and so had clearly directed the director of higher education to hear the petitioner as well as the principal of so and thereafter pass final order for appointment of the assistant professor. But instead of doing that, my lord, what he had done, that was their, my lord, argument, and accordingly it was accepted, my lord. It was their argument, my lord. Accordingly, that was accepted. So director was again, the matter was remanded to director to pass an order as per the, my lord, page 42 only. Considering the page 42 order. Now, my lord, the another speaking order on the basis of this is passed, which is impugned now at page 57, my lord.
57.
Yes, my lord.
What is 51?
51 was challenged, my lord. 51 was challenged, that is set aside. 51 passed an speaking order prior to that. One speaking order he passed director, saying that I heard the parties. After going through those parties, hearing the parties, it is seen that my lord, if your lordship may see page 51 last part, my lord. For this, another meeting speaking order was passed. Page 51 second last part, my lord. It may be noted here that the review of the selection committee would be done at the office of the Director of Higher Education Assam. Also the original records of the, so he said that the marks review is not within his jurisdiction. So it may be pressed before the selection committee to review the marks, my lord. And accordingly, the date was fixed 23/20/25, my lord.
Okay. Then the speaking order was passed.
Yes, my lord, on 23/20/25, even, my lord, if your lordship see the impugned order, page 57, my lord. This is the impugned order. Here, your lordship will find last part of the order, my lord, page 57. Since, my lord, from since.
Yes.
Yes, since awarding of marks for publication is a matter of considering subject expert, the director deem it fit appropriate to seek a re-verification of the selection committee. Accordingly, on 23/20/25, the committee was called, but due to absence of members, verification could not be completed. This is not the fact. Therefore, thereafter, on 18/8/2025, 2 subjects experts were deputed to verify the marks in the presence of the undersigned. This is again same mistake committed by the director, which was committed earlier, my lord. Same mistake. He was not directed to review the marks or to depute any subject experts. This was not the direction of this honorable court. But he gone beyond the jurisdiction and appointed 2 experts to verify the marks. And on the basis of that, he has passed against this impugned order, my lord. The same mistake committed by this authority, which was earlier committed. And that is to, my lord, by giving a wrong conclusion, but not a wrong observation, that, my lord, on 23/20/25, committee was called, but due to absence of members verification could not be completed on 23/2025.
Who is
The
the
committees-
petitioner? Who is the petitioner? Principal?
Principal, my lord.
Why?
He was present there.
No, why is the principal coming before the?
My lord, the principal, they are the selection committee, my lord. They had the right to select and they had forwarded the proposal. Now principal is directed to resubmit the proposal again. My lord, in fact, my lord, we have no problem if this selection process started in 2020, my lord. It's continued today, 2026. She has filed more than 3 times, my lord, writ petition after writ petitions. And it has been continuing for last 6 years. We are the sufferer, my lord, most sufferer. So, in fact, if your lordship directs, my lord,
So,
probably my learned friend will be not agreed, my lord.
no, I thought it was the candidates who had
No, no, no.
approached this court. Now is the principal coming before the?
Principal and the governing body, my lord.
Why,
Governing-
what is the ground for coming?
No,
to court?
my lord, they selected, my lord, their proposals were sent. The proposal was placed before the director. In each and every dates, my lord, each and every case, they were party here. Earlier cases, my lord. They submitted their everything there before the director, my lord. In fact, on that particular day, my lord, which the director has given an observation that on 23/2025, no members were present. The petitioner before your lordship, both days were present in the, my lord, director office. They submitted their proposals. He did not mention anything about that proposal, my lord. Even if your lordship may kindly see.
How
page-
do we determine that? Who was present, who was not present?
No, page 55, my lord. Page 55. This was held on his request, my lord, director's request. The petitioner before your lordship and other committee members were set in the director's office, my lord. Page 55. This minutes was prepared in the office of the director, my lord. And this was submitted on
Okay. So principal was present.
Principal was present. This, my lord.
Number 2.
Yes, number 2. Chairman was also present. Purobi Dwara, all they sit together, my lord. But the director has said, my lord, on 23/2025 committee was called, but due to absence of members, all members, verification could not be completed.
Due to absence of,
All members,
how many members are there?
absence of all members. In the selection committee, there were 6 members, my lord. The 4 members were present. And as per my lord, I have annexed another representation. 2 members, they have said, sent a representation, page 53, my lord. That is also there. Copy,
What did they say?
they said, my lord, they will be present in the last part, page 54. My lord, last part. Owing our extreme demand academic schedules, we regret to inform you that we are unable to make a physical visit to your esteemed office at this juncture. However, we remain available for any discussion on deliberation online mode conducted by your office as part of the resolution process. In fact, they have given some, my lord, suggestions, their views also in the prior paragraphs. So ignoring all this, my lord, director has appointed to, my lord, deputed to unknown person as expert going beyond his jurisdiction. My lord, and on the basis of recommendation of those 2 experts, my lord, he superseded the, my lord, the entire selection process. So at this is this, my lord, what my submission is. My lord, if my lord, my learned friend is, obviously he will not be agreed. My lord, if the selection process, entire selection process can be, my lord, done again, because this process is continuing for last 6 years, my lord. And in fact, it has to be completed within 45 days.
Let us come to page 42. The first direction.
Yes. Page 42, my lord.
You are saying that this was not complied with.
This was not complied.
Let us read, please read that on receipt.
On receipt of the representation, Director, Higher Education, Assam shall hear the petitioners in person, as well as the respondent number 3, Principal, Silapathar College, Silapathar, and respondent number 4, Brajen Sharma, and thereafter pass final order for appointment of Assistant Professor in the Department of Assamese in Silapathar College, Silapothar by taking into consideration of the office memorandum dated 8/12/2018 as well as the office memorandum dated 25/6/2016 within a period of 4 weeks from the date of receipt of the representation. Till that was the direction, man. Then on the basis of this, my lord, page 43 was passed.
So basically what it says is that the director will hear the parties
Yes,
and also the principal
yes,
and
Brajen Sharma.
and also take into account the OM dated
Yes, OM dated so
8/12
two
and
OMs, my lord.
25/6
Yes, ma'am.
and pass an order.
Yes, ma'am.
That's it.
That's it. My lord,
So what has he done?
in page 43, my lord, in fact, that was their submission in earlier route of litigation. My lord, in page 43, same thing was done by the director. My lord, here also page 43, if your lordship may kindly see, earlier speaking on that.
No, let us skip that 43 for now. 43, like there was a mention about OSD
OSD.
giving some report.
Yes.
So court said that OSD
No, here also, my lord, same thing. That's why I'm saying, my
in
lord.
57, what is wrong in 57?
No, my lord, how can he appoint expert thereafter on 18/8/2025? My lord, if your lordship may kindly see, page 57 last, my lord, which I have read earlier, man. Since awarding of marks, this, man.
Read that.
Yes,
Since
last
awarding,
part. Thereafter on,
no, since awarding of marks.
since awarding of marks for publication is a matter of
No,
concerning subject
no,
expert.
before that you read from here.
Yes,
Some OM also has been referred to here.
yes, OM is referred, my lord, whereas reference paid in office OM dated in the fourth para, my lord.
Both OMs have been referred to.
Yes, both OMs will. Both OMs, my lord.
OM dated 25/6/16, then 8. I think you should read from there.
Yes. Whereas reference is made to office dated OM dated so and so, which provides that any selection of the state government job with effect from so and so shall debar an employee from applying any other state level government job in the same position for maximum period of 3 years. If any such application is made, the candidature shall stand cancelled from both ends. In the present case, it is noted that respondent number 4, so and so, Brajen Sharma, applied for the post of assistant professor in Department of Assamese Government Middle College and Daythor, district so and so, and received his appointment letter on 16/12/2020. That is after the interview held at Silapothar College on 17/2020. And hence it is found that Dr. Brajen Sharma has not violated the provisions of the said OMD as he has not in government service on the date of interview of Silapothar College. So that is negated, man.
Then next one.
Yes. Then whereas the director has also examined the selection process under government so and so, that is 18/11/2018, relating to the selection of assistant professor librarians in so and so college. It is noted that under the clause this is clause 2(4) of the OM, research paper articles in the concerned subjects domain published in the impact factor journals existing in the debates of Scopus, database Scopus, website so and so, 2 marks for each publication subject to maximum 4 marks shall be awarded. The petitioner claimed full marks of 4 marks for her Scopus publication. However, selection committee did not award any marks under the head hereby recording 0. Since awarding of the marks, selection is matter concerning subject expert, the director deemed it appropriate to seek re-verification by the selection committee. Accordingly, on 23/2025, the committee was called up, but due to absence of all members, verification could not be completed. That was, my lord, on 23/2025. What happened thereafter, my lord? Thereafter, on 18/8/2025, months after 4 months, 4 or 5 months, my lord, 2 subjects experts were deputed to verify the marks in presence of undersigned. How can he do that, my lord? Same mistake. Earlier it was by the OSD. Now it is by the another 2 subject experts who is unnamed expert, my lord. He has not mentioned the names also. It was not the direction of the director, this honorable court. So upon verification, both the experts commented that, and on the basis of that, both experts, this OM is this, my lord, impugn order is passed. and it was remanded back to the college authority for checking, my lord, taking fresh proposal. In fact, earlier also, it was not my argument, my lord, that OSD, it was my submission that it was under the supervision of the, my lord. That was my submission in earlier case. It was under the supervision of the director. OSD done the entire work, man. So OSD, the director did not commit any wrong. That was my submission. But their submission was that no, he cannot do that. That was their stand in that writ petition. According to this, the director was remanded, the matter was remanded to director for taking passing final order. He has not passed any final order, my lord. He has in fact committed the same mistake by appointing deputing to another expert, unknown name is not disclosed. Again, same mistake committed. So at this stage, my lord, my learned friend is there. They have also filed a writ petition probably.
A caveat term in this case, my lord, for respondent number 3. My lord, kindly turn to page number, my lord, that 55. Why 2 subject experts were deputed, my lord?
You are for?
I respondent number 3, the caveat, my lord.
Respondent number 3.
Beneficiary, my lord.
You are the beneficiary.
Yeah, my
Yes.
Paragraph, page 55. The 4 members were present, my lord. In terms of the direction issued by the director, white page number 51. 13/3/2025, a sitting order was passed for verification of the original records. And at page 55, 4 members were present. Number 3, Dr. Purabi Dwara. She was the subject expert, my lord. There were 3 subject experts. In this meeting, 1 subject expert was present. 2 were absent, my lord. Therefore, 2 subject experts were deputed. And my lord, there was a specific direction from this honorable court to the director to pass a speaking order by considering these 2 notifications, OMs. He has considered the OMs, my lord. As my lord, the subject experts were not there on 20 of March. And my lord, there is an urgency on the part of the college authorities to fill up this post. Therefore, my lord, this step was taken. And my lord, the expert committee verified the records and arrived at this conclusion, my lord. Therefore, my lord, these 2 experts were deputed. Because on that date, 3 experts were not there. So this is the reason, my lord. And my lord, so far as the locus of the petitioners are concerned, my lord, I'll pray before lordships to kindly go through the page 437 of our education manual, Assam Non-Government College Management Rules 2001, page 437.
Yes.
Page, rule 2, definition, 438 page. The definition is college is there, my lord. College means a provincialized college and a non-government college. So this is the provincialized college, my lord. And this rule is in frame to define how a governing body will work, my lord. The constitution of a governing body and how it will work.
No, why are you referring to 2 definition of college?
My lord, that provincialized college, our college is provincialized.
Ah.
That is why I'm referring this, my lord.
Okay.
Rule 12, my lord. I'm referring this, that this rule is applicable to the governing body of this particular college.
Okay.
Rule 12, meeting of the governing body. The governing body shall meet at least once in every 4 months, earlier it was 6, but it may meet at shorter interval also if circumstances so demands and the president of the governing body is satisfied that such meeting is necessary. My lord, for taking any decision of the governing body, this is a collective body, my lord. There has to be a meeting, there has to be a proposal. There has to be a presence of the members, my lord. There has to be resolution authorizing someone to file a court case on behalf of them, my lord. Where is the authority of the governing body to the petitioners to file the instant writ petition, my lord? and what right, what fundamental or legal right have been violated of the petitioner number 1 and 2, that Brajan Sharma, his number has been deducted, my lord, by the director. He is not a person aggrieved. The person aggrieved here is the president of the governing body and the principal, that too without any resolution and authorization by the governing body. If it permits, my lord, then my lord, tomorrow, a parent of the student is also a member of the governing body. He will also come to the court, my lord, on behalf of the governing body. If the president can come, if the principal can come without resolution, without any authority, then tomorrow, my lord, the parents of the guardian will also come on behalf of the governing body without any resolution. Where is their authority to file this writ petition, my lord? This writ petition has been filed only to favor Brajan Sharma, my lord. From day one, they are against me, my lord. I am deprived from the marks entitled for. And now director has verified all the records and arrived at a conclusion that yes, I should have been given 5 marks, which they did not given. And Brajan Sharma was illegally given some marks that has been deducted by this order, that impleadment instant writ petition. But he is not before a lordship, my lord. He has not any grievance. But the grievance is president and the principal. They filed this writ petition that they are suffering because students are suffering. But they want to appoint this Brajan Sharma.
Okay, tell me, how many writ petitions have been filed so far, apart from this?
My lord, the advertisement was issued on the earlier occasion, my lord.
Who all had come? You
My
had
lord,
come
3
also?
petitions have been filed, my lord.
You had come also?
Yes, my lord.
He had come 3
I'm
times, ma'am.
petitioning the other writ petitions.
How
my
many,
lord.
how many writ petitions you have filed?
Now one is pending and the
One is pending.
one is pending, that is listed today as 52. My lord
Item-
may come to first, my lord.
Item
Yes.
52.
Item 52. This is listed today. First, I filed 5663 of 2020 at page 35.
Sorry? Case
My
number?
first writ petition number is 5663 of 2020
Hmm.
at page 35 of the item 6.
Then that is
That
disposed of.
was disposed of, directing the respondent authorities to bring the selection process, the present selection to the logical end.
Then
Thereafter,
Second. Second,
second one was at page 38. It was numbered as 7061 of 2021, wherein a direction was given to the director to pass a speaking order by considering the OM dated 8/12/2018 and 25/6/2016, which has been done in the present case, in the present order. Thereafter, the same exercise was done and it was done by the OSD. Therefore, this honorable court was pleased to set aside that order. Lordship will find at page order page 50. And this writ petition was numbered as WBC number 4605 of 2023.
4605.
05 of 2023. All are disposed of.
This is also filed by you.
Yes, my lord.
4605.
Yes, my lord.
Page number?
Page number 44
Hmm.
of the item number 6.
So that's all you have filed, 3.
Yes, my lord.
Now-
Now the fourth
now
is
the
pending,
fourth-
my lord. This is listed today.
4th is pending.
Yes, my lord. 7182. They are my.
What have you challenged in the 4th?
My prayer is to, my lord, to direct the principal to implement this order, my lord, that is
I see.
presently pending. And that was filed earlier at point of time, my lord.
So these 3 cases you mentioned is already all disposed, isn't
All
it?
disposed of, my lord.
Pending is that item 52.
52 7182 of 2025. And the service is complete, my lord, in this.
Just a minute, with 7182.
And by the order dated 6 September 2025, the principal is directed to rectify within a period of 15 days. As no action was taken, therefore I filed this the present writ petition. So, my lord,
Who are the other parties?
my lord,
Who are the other parties?
Brajan Sharma.
Principal, then you are one of the
Yes, my lord. And the,
beneficiary, then who else?
and the blue-eyed person of the principal, Brajan Sharma.
Huh? Brother.
Brajan Sharma, my lord, for whom they are fighting, my lord.
No, we are not fighting for Brajan Sharma. How can he allege that?
No, Brajan Sharma, is he related to anybody? No.
No, my lord, he is not related to anybody, my lord.
Okay.
But in my writ petition, he is a party respondent. In the present writ, he is not. My lord.
Okay.
And the service is
And
complete upon him.
You are for the department. Anything you have to say?
rightly pointed out. First of all, is petitioner neither to file in this instant case man.
You're for the director. Definitely, you say that.
Regarding this speaking order.
See, I've understood the problem. Only thing is that he's the caveator now. And there's one more matter at item 52.
Their service is completed.
It'll be better that these two matters are clubbed together.
Yes, yes, yes.
And if you have any objection like with which you have raised right now
Yes,
on the maintainability of the thing,
read petition.
you file that.
I
We'll
file
fix, we'll fix a date and we'll
My lord,
take a call.
My lord.
Only at this is this, my lord, my prayer is then, my lord, status, because this has been, this was a state since 2020, my lord. On their instance, it was a state since 2020, my lord.
My lord, at our
The appointment was in state on their application. So at this state, status quo as on date maybe.
My lord,
Who's appointment? Anyone can
Appointment was state.
it was directed by this honorable court to bring the selection process to a logical end, my lord. It is not that at our instance, our case.
No, on their application, it was a state. All this appointment was a state. This appointment was a
So
state.
since
since
they have some
2020.
urgency,
So we'll issue notice on this and we have a short date.
my lord.
You file your objection, you file reply to whatever
My lord,
and
my
we'll
lord,
take a call.
We'll file, my lord.
When can you file?
My lord, within
Today
10
is
days,
21st, is it?
21st, within 10 days, my lord.
First week of February?
First week of February, we'll file, my lord.
All parties agree? We have a fixed date on first week of February?
More to.
Any convenient date?
My lord, can it be on 12th of February, my lord? Thursday.
All right.
Till then, my status quo is on date, because I'm not saying that stay. Because it was not appointed since 2020, my lord.
Is it required to say status
There is
quo?
no such requirement.
Otherwise, my lord, the director may again ask, because we have informed the director, my lord, that we have preferred a writ petition before this honorable court. However, my lord, director may ask again me for implement. That's why.
There's a case pending, so
Yes, since the matter
Yes.
is up to this, my lord.
That's why, my lord. That's why status quo, there is no problem on that one. Probably
please write hard Mr. J. Payam, learned counsel for the petitioners who submits that by filing this writ petition, the speaking order dated 6/9/2025 passed by the Director of Higher Education, Government of Assam, on the ground that the same is beyond the jurisdiction of the state authority, having regard to the direction passed by this court in the earlier litigation filed by the you're not a respondent here,
Yes, yes, I'm respondent number 3.
filed by respondent number 3. Namely, Sri Deepak Barua.
Deepika Purva.
Oh, Deepika. Srimati Deepika Barua. That is IE WPC number 5663 of 2020. Stop at this stage, Mr. RM
RM Dekhan.
Rekha, learned counsel, submits that he has instructions to appear on behalf of respondent number 3 and
His
that
caveat, my lord.
I'm on caveat, my lord.
respondent number 3, isn't it?
Yes.
Respondent 3 and that he is also the caveator. Stop referring to the writ petition. The learned counsel questions the maintainability of the writ petition, since there is no authorization from the governing body by way of a resolution.
We have resolution, my lord. I could not annex, I will annex.
So he also submits that the respondent number 3 has also filed a writ petition, namely WPC number 7182 of 2025. Listed as item number 52 in today's cost list, seeking the implementation of the speaking order challenged by the instant petitioners. Next para, considering the above position, it would be for the it would be appropriate to hear both the cases together, both on maintainability and as well as on merit. After giving the opportunity to the parties concerned to project their respective case. So since the present case is listed in the motion column today, let notice be issued returnable by date 12/2/2026. Mr. S. Das, learned counsel for the higher education, appears and accepts notice on behalf of respondent number 1 and 2. Mr. R. M. Dekar, learned counsel, accepts notice on behalf of respondent number 3. Notice is complete. Extra copies will be served within 2 working days. Parties to exchange their respective pleadings on or before. What was the date I said? 12, no? On or before 10 of February 2026, so that the matter can be taken up for final consideration on the next date fixed, on the next returnable date. No. List this matter along with WPC number 7182 of 2025 on 12th of February 2026. Since the matter is being since the matter is sub judice, no, cancel that. Till the next returnable date, status quo as on today shall be maintained by the parties.
In my lord, 7182, my lord, will appear for respondent number 3, 4, and 5. I will appear.
Who are they?
The
College authority, my lord. Governing body and principal and
You have not appeared earlier.
no, I have filed my Okalanama in that case.
On the last
Yesterday.
occasion, notice was issued in that matter. It is listed today, and the service is complete, madam.
It's okay. Okay.
Yes.
Let me pass the order down. Separate order, huh? Item number 52.
50.
R. M. Dekar, learned counsel for the petition is present. Mr. J. Payak, learned counsel, submits that he will be appearing on behalf of respondent numbers 3, 4, and 5. As such, notice is complete on response. You have received?
Yes, my lord, I have received.
Okay. Then Mr. S. Das, learned counsel, appears for respondent numbers 1 and 2. 1 and 2.
1 and 2.
Yes.
I have received.
List the matter on 12/2/2026 along with WPC number 23 of 2026. Parties to exchange their pleadings in the meantime, please advise.
And in the second matter, service on respondent number 6 is also complete, madam. Flag TC, madam. And there's the office note, madam. Like
The Payang was 4, which,
345, my friend.
345.
is
oh, there's 6 also.
Yes,
Six is there, service upon him is also complete, my lord, as per the office movement. Like PC.
But no steps has been received by the section for issuance of notice upon respondent number 3 to 6 by Dusty. Who is number 6?
That Rajan Sharma, my lord.
Who was earlier selected, man?
I see. Write one more line on perusal of the office note dated 19/1/2026, which states that as per the postal tracking report, notice has been delivered to respondent number 6. Comma, notice is accepted to be complete on respondent number 6.
Deep lovely.
Okay.
This is on.
May I please your lordship, my lord. My lord, I take the lordship page 159, Annexure 4. We have challenged this notification of the Government of Assam dated 30th of August 2025. While some new guidelines has been given against the judgment of the order passed in WBC number 34225, Abdul Qadir Bokshi versus State of Assam. We have challenged this order because our petition is pending before the Honorable High Court regarding competition and appointment. Only notice may be issued in this. And several cases are pending before the Honorable High Court.
Which one have you challenged? Which part?
The whole notification has been challenged because I take your lordship page 157, the judgment passed by my learned Honorable Judge, Justice Suman Shyam, para 10, kindly see, page 157, para 10.
No, I'm
It is
talking
made-
about, you're talking about the executive order, isn't it?
Yes, yes.
Any particular clause which you are aggrieved with?
My lord, it whole is wherein it says that our cases may not be considered in pursuant to this order notification. That's why. Because our cases are pending still, my lord.
Heard Mr. S.C. Biswas, learned counsel for the petitioner, who submits that by filing this writ petition, the petitioner has challenged the executive order dated 30/8/2025 issued by the Department of Personnel, Government of Assam. Since the same precludes consideration of the case of the petitioner for compassionate appointment. Next para, in view of above, issue notice of motion returnable by 4 weeks. Ms. S. Kaur, learned state learned standing counsel.
Lordship. There is no standing counsel notice.
You are GA, isn't it?
Lordship.
Learned government advocate accepts notice on behalf of.
But for all the respondents, my lord, friend will appear.
For all.
Yes.
Lordship, may kindly come to page number 32, Lordship. Their prayer portion, Lordship. Their prayer portion. They are challenging the DLC minutes, Lordship.
Yes, Mr. Biswas.
Yes.
She's
No,
correct.
it is my petition pending before the court. The writ petition, copy I have annexed. My prayer here before it is that page 12, my lord, kindly see. Pending dispatch of the matter of operation of impugn executive order dated 30th August 25 issued by the respondent to Commissioner Secretary to the Government of Assam. This poor may suspended state for the influence. Page 12. Page 12, my lord.
Page 12.
12 of my writ petition.
Oh. Miss Kaur, they've annexed something else.
Yes. No, my lord. Yes. It is there, my lord. No, it was Agor petition.
He has annexed, the writ petition as annexure 1.
Yes.
Ms. S. Kaur, learned government advocate, accepts notice on behalf of all the respondents. Extra copies be served to her within 2 days. List again after 4 weeks. List again on 5/3.
May I please, your lordship?
Yes,
I have approached on earlier occasion also, lordship, but it was withdrawn with liberty to file a fresh lordship. So petitioner mother is a disabled person, lordship, and petitioner mother died in harness. She was serving as a teacher, lordship, and ultimately, lordship, he filed a pension paper, and some amount has already been given also, lordship, for his family pension, lordship. Lordship may kindly look at annexure 10, page 47, lordship.
why have you come before this court?
Lordship,
Why have you come? What is your grievance?
my grievance is, lordship, after paying certain amount, lordship, the authority has stopped the family pension and gratuity amount, lordship, for my mother's, lordship. I'm the petitioner brother is a disabled person. Petitioner approached for her disabled brother, lordship, for family pension of her mother, lordship. Ultimately, lordship, annexure
Who
10,
expired?
lordship,
Who expired?
mother expired, lordship.
Mother expired.
Mother.
Mother was a teacher.
Lordship. She was serving as a LP school teacher, lordship.
And after her death,
Lordship.
who was getting pension?
Lordship. Annexure, page 6, lordship, page 4, petitioner mother was serving. Thereafter, para 5, lordship, while he was serving as practicing LP school Rongia, she died in harness, lordship, leaving behind a disabled son and other 2 married daughters, lordship.
Married daughters are not entitled to.
No, lordship, I am,
But listen, but there is a son who is disabled.
lordship,
He was getting provisional pension, but it stopped.
stop, lordship. That's why I have come, lordship.
Why it stopped? There must be a reason.
Lordship, may kindly look, I may read, lordship, annexure 10, lordship.
What is the next 10?
Annexure 10,
Draw
lordship,
statement.
page 47. The dirt
What
statement.
is the draw statement? What do you want to show about with this?
Next, lordship, annexure 11, page 48. It is clearly mentioned, lordship. May I read, lordship?
No, just a minute. This page 47.
Page 47 is a statement,
Uh,
but already given,
is-
lordship.
Listen to me.
Lordship.
Page 47 is an amount
Lordship,
which was received by the disabled son.
disabled son.
That means from 2016 to 2021.
21, lordship.
This much only.
Lordship.
After 21, he has not received.
No, lordship.
Then-
The communication has been,
Have you sought for any? Have you filed any representation?
lordship.
Did you approach the respondent authorities with your
Lordship, I have
grievance?
time and again approached, lordship.
How?
I am the 50% petitioner brother is a 50% disabled person, lordship. So petitioner and some other family members already approached, lordship.
How?
Is it
By
at
which
the office,
letter?
lordship? No any representation, but lordship.
Then how do you know that you approached?
Lordship, may I kindly
Simply
look at
submitting orally will not.
para 17, lordship. Para 17, Para 17, page 14, Lordship. Family event, time and again. Visited the office of the respondent to learn about the non-release of regular family pension and for disabled mother, including area reviews. Lordship. And ultimately come before this honorable court, Lordship.
You went before the deputy inspector of schools.
Lordship.
Then what was the reply?
Already, they wrote.
This is very vague.
Treasury officer wrote to the director of pension also, Lordship, Annexure 11, Lordship, page 48.
There is something wrong with your disability certificate, I think.
I have submitted, Lordship, that is, I have also annexure, Lordship,
You don't know why it has been stopped?
Lordship.
Why has your pension been stopped?
No reason has been, oh, Lordship, something, Lordship, annexure 13, page
Then
53,
you filed a
Lordship.
presentation. You filed a presentation asking them why you have not given me pension.
No, Lordship, may kindly
Then you
go
come-
to the annexure 13, Lordship, page 52. May I read, Lordship?
Page?
Page 52, Lordship. Last page, Lordship.
Read.
May I read, Lordship? It is returned to the Deputy Inspector of School from the Director of Pension. With reference to the subject side, quoted above, I am to request you to resubmit the proposal as per checklist for disabled pension to the concerned district commissioner after proper verification and attestation at the earliest.
So you
So
should
at
approach
least
the deputy inspector of schools.
So, Lordship may at this stage notice may issue, Lordship. They will reply, Lordship.
Who is the petitioner?
Petitioner is the elder sister of the
Gayatri Chaudhary.
Gayatri Chaudhary, Lordship. She approached, Lordship, as the petitioner for her brother, Lordship. She is having 50% disabled. That's why, Lordship.
It should be the brother who should come. Why sister has come?
For her,
Married sister is not entitled to pension.
no, Lordship. Prayer is for releasing pension for her brother, Lordship.
I know. The brother should file.
No, he is a 50% disabled, that's why, Lordship.
Maybe. His name will be there. He'll authorize the sister. Why sister has come?
Some activities does not permit him, Lordship, to approach. That's why, Lordship.
No, no.
I have mentioned in para 1,
Where have you stated?
that the petitioner approaches before you, Lordship, for her brother, Dikishan Chaudhary. And I have annexed his disabled identity card issued by the authority, Lordship. That is page 23 and Annexure 2, Lordship.
There's a technical defect. Like I said, the brother should be the petitioner.
So he is a 50% disabled lordship. He's
See, Mr. Counsel, even supposing a person is a minor, 5 years of age. Mr. A is only 5 years of age. The cost title will say Mr. A, represented by legal guardian so and so, like that. Here, the name is the sister.
but prayer portion is clear, lordship.
No, it's not clear.
Lordship, may
It's
go
not
to the
clear
prayer
at all.
portion, lordship. Lordship, may kindly look at the prayer portion.
It's not clear
I
at
have
all.
never
Not only the
Suppressed.
prayer portion. Look at the affidavit, look at everything.
So notice, at least notice may go, lordship. What result they come.
Notice will not go just because you ask for it. You have to, you have to correct that. Let the person come in his name.
Being disabled, that's why I could not come, lordship. Petitioner, brother could not.
Oh, he'll come and authorize the sister. Sister will come and swear the affidavit saying that I'm authorized by my brother to file this writ petition. Do that. You withdraw this and file afresh in the name of the brother. Please write. By filing this writ petition, the petitioner has sought for grant of pension for her brother, who is said to be 50% disabled. To stop, it is seen that the disabled brother is not the petition in this writ petition. Stop, the affidavit also does not indicate that the sister has been authorized by the brother to file this writ petition. Under the circumstances, this writ petition is closed.
Lordship, I may be allowed to.
With liberty to file afresh in the proper, to file afresh as would be permissible in law. You file.
Lordship, obliged.
Yes.
My lord. My lord, the petitioner is the senior most postgraduate teacher in TC Girls High School. Now, what had happened, my lord, is that the earlier principal of the school retired on 31st of January 2023. Thereafter, respondent number 5, my lord, was inducted as the principal in charge of the TC Girls School, bypassing the seniority of the petitioner. My lord will kindly come to page 40. Page 40. This is the impugned order, my lord. Paragraph number 2. If I may read, my lord.
Yes.
On verification of seniority list and other relevant documents, it is seen that only one Srimati Subhalakshmi Borua, assistant teacher, obtained B.Ed degree on deputation. The other teachers of the seniority list who are senior to her and have B.Ed qualification could not produce the necessary order/permission of the appointing authority for pursuing her B.Ed degree. As per clause 13 of the Assam Civil Services Conduct Rules 1965, no government servant while in government service shall join or attend any educational institutions for the purpose of preparing himself or shall appear in an examination of a recognized board or university without obtaining previous permission from the appointing authority. My lord, I had not prosecuted sanction for my B.Ed degree, my lord. That's an admitted fact.
Your name is reflected here? No.
No, my lord. My name is not reflected here. Respondent number 5's name is reflected, stating that she had undertaken her B.Ed degree on deputation with permission. Now, my lord, I had followed it up with two representations pursuant to which at page 49, my lord, there was a hearing schedule between me and the private respondent number 5. Page 49, Annexure K. In reference to the subject cited above, I am directed to state that the hearing is scheduled to be held on so-and-so at 3 p.m. in the office chamber of the undersigned in connection with the complaint regarding appointment of principal in charge of TC Government Girls High School and MP School. Your Lordship sees 1 and 2, my lord, Srimati Subhalakshmi Borua at page 49.
Yes, R5.
Subhalakshmi Borua is respondent number 5. And my name, my lord, Srimati Mollika Devi, I'm the petitioner. Now that hearing took place and there was no response from the authorities, my lord, which prompted the writ petitioner to file an earlier litigation, my lord, WPC number 3643 of 2025. Those orders, my lord, are annexed at page 50 and 53. 50 and 53 notices were served, had not entered her appearance in spite of the notices being served, my lord. That is at page 53. Page 53, my lord. Your Lordship has seen that? Yes. Now what has happened, my lord, when the matter was taken up on 12th of December 2025, a hearing report was produced by the Government Council, my lord, which is under challenge in this writ petition. The hearing report starts at page 54, pertaining to the hearing which was scheduled, my lord, which was pointed out before this honorable court at page 49. Yes. The hearing report starts at page 54. It's an undated report, my lord. The report has not been dated, but it was produced before the honorable court on 12th of December 2025 when the earlier writ petition was held. Now, my lord, the findings of the matter, my lord. On perusal of the representation, my lord, the last paragraph, my lord. On perusal of the representation and gradation list of the school, it is observed that Srimati Bandana Thakuria, there's another incumbent, PGT, is the senior most teacher of the school, but she does not have a B.Ed degree. Sri Mollika Devi PGT, which is the petitioner, my lord, is the second senior most teacher with a B.Ed degree, which was taken without prior permission from the appointing authority. Whereas Srimati Subhalakshmi Borua, assistant teacher, who is the respondent number 5, my lord, the current in charge, is the third senior most teacher with a B.Ed degree obtained with prior permission from the appointing authority. Srimati Subhalakshmi Borua was found to have all the required qualification for acting as a principal in charge. Thus, she was allowed to hold the charge by order number so-and-so, which is a part of the writ petition, my lord. Now, your lordship will kindly come to page 55. The second paragraph, my lord, that starts from the 4th line. In the order of the Honorable High Court, dated 27/2/2025 in WPC 3929 of 2024, Madhav Chandra Kolita versus the State of Assam, states that this court has taken note of the submission of so-and-so, Learned Standing Counsel for the respondent 1, 2, and 3, and Mr. Sharma, Learned Counsel for the respondent number 4, who had submitted that the petitioner is not eligible to hold the post of headmaster in view of Rule 13 of the Assam Civil Services Conduct Rules 1965, as he has obtained the B.Ed degree without formal permission of the authority. But the said submissions left this court unimpressed, inasmuch as through a long stint of judicial pronouncements, it has been established that a degree conferred by a recognized university is a valid degree and it cannot be invalidated even if it was pursued without permission from the authority. This is, my lord, there are around 6 judgments rendered by this honorable court, my lord, where it stated that without obtaining prior permission to obtain a B.Ed degree does not invalidate the degree, my lord. And on that count alone, my lord, in similar judgments, my lord, respondents...
No, you complete.
Yes, my lord.
Complete reading it.
Yes, madam. Moreover, a similar judgment was made by the Honorable High Court in WPC 4205/2024 dated 11/4/2025, which is further appealed by the government for modification, alteration, cancellation. As the matter is now sub judice, any decision on the basis of the above order could not be made at this point in time. My lord, this is a stand of the government. Now, my lord, we'll kindly come to the order which was passed, my lord, at page 56. Page 56, the same order which has been referred to by the state, my lord, 4205 of 2024, with page 56. Joyanto Neog and 13 others. Now, my lord, the facts of the case are at page 64. Page 64. Page 64. By the impugned communication dated 19/12/2023, the Director of Secondary Education, Assam Kahilipara, instructed all the inspectors of schools, Assam, asking them to immediately start departmental proceedings against those teaching and non-teaching staff or provincialized secondary schools who have acquired any academic or professional qualification during their service period without obtaining previous permission from the appointing authority in violation of the provision of Rule 13 of the Assam Civil Services Conduct Rules 1965, inasmuch as according to the Director of Secondary Education, Assam, pursuing any educational professional qualification by the teaching and non-teaching staff of a provincialized secondary school without permission from the employer violates Rule 13 of the Rules of 1965 and therefore liable to be punished as per the provisions of the Assam Services Discipline Repeal Rules 1964. This was the gist of the matter, my lord, which was adjudicated by the Honorable Court. It has no relevance to the case at hand, my lord. In fact, there have been numerous judicial pronouncements. They have stated that if an incumbent, irrespective of the fact of whether having obtained or not having obtained prosecution for B.Ed degree, has the B.Ed degree, my lord, and if that incumbent is a senior most incumbent, then the post of in-charge headmaster principal cannot be taken away. Now, the state has relied on this matter.
What is the outcome of this writ petition?
My lord, now the issue is, my lord, will kindly come to page 63. Page 63, my lord, for a moment, my lord. This order was dated 11/4/2025. Page 63.
Yes.
Now the state is saying that they have pursued an appeal. My lord, will kindly come to page 81. Page 81, my lord.
No, before that, you tell me, what is the outcome of this writ petition?
My lord, that is what, my lord, page 81 is where they have filed an IA for condonation of delay, my lord. The appeal is not yet heard.
No,
IA is
that
yet
is
to
not
proceed.
what I'm asking you,
My
Mr.
lord.
Counsel.
My lord,
Don't be too excited.
my lord.
See, you tell me, what was the finding of this court in this judgment of 11/4/2025?
My lord. The findings, my lord, they start at page 47. At page 78, my lord. Page 78, paragraph number 47.
Yes.
Accordingly, the determinations made herein above are summarized as follows. Permission to prosecute studies by a government servant in an educational institution is a sine qua non in terms of Rule 13 of the Rules of 1965. Such permission can be refused in terms of the proviso to Rule 13 of the Rules of 1965 when such prosecution creates dislocation of the work or stands in the way of efficient discharge of duties by the government servant and leaves a big gap in the working strength. The object of recognition of scheduled institutions for pursuing higher studies through distance mode is to facilitate the serving teachers to acquire the required professional and educational qualifications so that the standard of imparting education is maintained without hampering regular classes of schools and or without disturbing the day-to-day work. A conjoint reading of both the rules, Rule 13 of the Rules 1965 as well as Schedule 3 of the Rules of 2018 and the determination is recorded herein above, leave no room for doubt in the mind of this court that prosecuting higher studies by serving teachers without permission from the scheduled institution as enumerated under Schedule 3 of the rules cannot be termed as a misconduct in terms of Rule 30.
Just pause there.
Yes, my lord.
The court has held that even if you go there to pursue your further studies without permission, it cannot be termed as a
misconduct.
misconduct.
Yes.
Then permission?
Yes, permission mandated under Rule 13 of the Rules 1965 cannot be made applicable in prosecuting studies by teachers whose service conditions are controlled by Rules of 2018 through distance mode from the scheduled universities institutions enumerated under Schedule 3 of the Rules of 2018. Determination made in Mosumi Sohoria, my lord, that is one of the cases which I relied in earlier, cannot be termed as any direction to the authorities in Education Department to initiate departmental proceedings against all the teachers who prosecuted studies through distance mode from the scheduled institutions incorporated in Schedule 3 of the Rules of 2018. Number 7, when there is no dispute that the petitioners had obtained their degrees through distance mode from KKHSOU, IDOL, Guwahati University, Dibrugarh University, and Assam University, in terms of the prescriptions made under OM dated so-and-so, and OM dated 2019, my lord. Therefore, Rule 13 of the Rules of 1965 cannot be made applicable to this. Some of these facts are not applicable in our case, my lord, because the facts are slightly different. the gist of the matter, my lord, is that there have been 5 pronouncements of this honorable court which have stated that non-prosecution might be termed as a misconduct, but that does not invalidate the B.Ed degree which has been held by an incumbent. Now, this was the reason which was taken by the government of denying me the post of in charge principal of the school. Subsequently, my lord, there have been judgments cited by this honorable court. Now, the government is saying that the matter is under appeal before the honorable division bench. Now,
Which matter? Which matter?
This order, my lord. This is under appeal regarding pursuing departmental proceeding, my lord. This is nowhere related to my case. The facts of this case does not match with the facts of my case.
Then you are showing me page 81.
Page 81. Page 81 is the IA for condonation of delay, my lord. That order your lordship had seen was passed in the month of April 2024. This IA, my lord, filing date, the second column, my lord, September 2025. And that is still in the stage of being condoned, my lord. The appeal is not yet been listed, my lord. The IA might not even be entertained by the honorable division bench. And there are categorical judgments, my lord, of this honorable court, which have stated that non-prosecution under Rule 13 cannot be taken as a ground to deny an individual his right under the degree that he or she has obtained. That is my case. It is not in dispute that I am the senior most. It is their admitted statement that I am the senior most with a valid B.Ed degree. Vandana Thakuria does not have a B.Ed degree. I have the B.Ed degree, I am the senior most, and respond number 5 is the second senior most. It is their stand. But that is my case, my lord. Respond number 5 did not enter appearance in the earlier litigation. And I have filed this writ petition to challenge the hearing report, which was produced before this honorable court on 12th of December.
What has happened to that writ petition? Still
That is
pending.
still pending, my lord. That is still pending, but that cannot be decided unless this matter, that writ
What have you challenged in that?
setting aside of the order which had, my lord, put the respond number 5 as in charge.
Okay, in charge.
This was the
This is
initial-
regarding report.
This is against the hearing report. The hearing report is on that ground of the appeal being pending before the honorable.
So we'll issue notice and club it together
My lord,
at this stage.
my lord.
Heard, Mr.
M. Sharma, my lord.
M. Sharma, learned counsel for the petitioner. Submits that by filing this writ petition, the petitioner has challenged the hearing report dated 4/6/2025. Bracket annexure. Annexure M or annexure I?
My lord.
What is the number of the annexure? Annexure I? Or annexure M?
And, my lord, annexure M, my lord. Page 54 is the hearing report, which has been impugned, my lord.
You have not erased the annexure on top. It says annexure Roman 1. Below, again annexure M. You write annexure M. Page 54.
Page 54, my lord.
There are 2 markings, annexure. Annexure Roman 1, below that annexure M.
My lord. My lord, my apologies, my lord. It should be ideally annexure M.
It should be M.
My M, my lord, M.
Bracket annexure M. By which the petitioner has been denied from being given the in charge principal post of TC Government Girls Higher Secondary and MP School,
My lord.
despite being the senior most qualified teacher. So the learned counsel submits that respondent number 5, who is the second senior most, who's junior to the petitioner,
My lord.
has instead been appointed as the in charge principal by order dated 27/1/2023,
27, 1, 2023, my lord.
bracket annexure G. which the petitioner has challenged by filing WPC number
3643.
3643 of 2025.
Right.
And the same is still pending as on date. In view of above issue notice, returnable by. When is it listed, the other case?
My lord, no date has been given, my lord.
Returnable by 3 weeks. Miss
NM Sharma.
NM Sharma, Learned
Response number 1234.
Standing Council. Higher education? Or secondary?
Lordship.
Secondary education. Accept notice on behalf of respondent numbers 1,
2, 3, and 4.
2, 3, and 4.
Lordship.
Petitioner to take steps for service of notice upon respondent number 5 by speed post within 3 days. This matter again also in so. 24-2 along with WPC number
3643
3643.
of 2025.
3643 of 2025.
Yeah, please, Your Lordship. This matter related to non-appointment under compassionate ground, Lordship. And and I file a representation, Lordship. Page 13, Lordship. Sorry, and page 73. Annexure 13. This representation has been filed pursuant to notification, Lordship, issued by the government, Lordship. That is page 12, Lordship. Sorry, 72.
You are late.
Lordship, late. The thing is that, Lordship, I have applied, I have rejected, then I approached before his honorable court. That also my rejected. Honorable court reject my petition, Lordship. The void of merit, Lordship. During the pendency of my writ petition, the OM has been issued, Lordship, and OM. That is page 49, Lordship. Regarding compulsion appointment, Lordship, new scheme of appointment and compulsion ground, Lordship.
Yes. Who died in harness?
Father, Lordship.
When?
Father died in the year 2008, Lordship. Then my mother applied on behalf of me. Then and rejected in the year 2011, Lordship, by the DLC.
Then?
Then I approached before its honorable court, Lordship. The honorable court had ordered had judgment order at 16/7/25. Reject my petition has been dismissed the void of merit, Lordship. Then during this pendency of my writ petition, Lordship, this OM has been challenged by other person, Lordship. That is page 63, Lordship. Sorry. Yes, 55, Lordship. Yes, 55. The OM has been challenged, Lordship. Other person apply for compulsion appointment, Lordship. And this relevant person is, Lordship, order of the relevant person, page 61, Lordship.
No, that we have seen.
No.
But you're late.
I am late, Lordship, obviously late. But this by this order, Lordship, page 61, Lordship, others the pending cases before DLC all has been set aside by this honorable court and directed to place Lordship. By this order, page 61, Lordship, para 9.
Pending case means pending writ petitions.
Pending writ petition, Lordship.
Your writ petition was pending.
No, my was disposed of. My one is dismissed before this disposal of this writ petition, Lordship. This order has been passed on 3/4/25, Lordship.
No, what was dismissed? Your writ petition.
My writ petition dismissed, Lordship.
By order dated?
By order dated.
Lordship, kindly came to phase 40, Lordship.
40.
Yes, Lordship.
Yes.
My order dismissed on 16/7/25, Lordship. And this order was passed before my disposal, Lordship. This was 3/4/25, Lordship.
So
I have no knowledge regarding this disposal lordship.
how does it help you?
Now my only
Your case was dismissed on its own merit.
lordship,
In another bunch of series of cases,
lordship,
court said that all pending cases will be taken care of
lordship.
since there was an admission on the part of the government council that will consider.
Lordship.
Court said, okay, consider everything for all pending cases. Your cases was not pending,
Not pending. My case dismissed.
or your cases was pending.
Not pending lordship. My earlier rejected a DLC, then approached before honorable court. That honorable dismissed my petition lordship.
No, your writ petition was pending.
Not dismissed lordship.
Your writ petition was pending.
No, my petition dismissed lordship.
Oh. The month of April comes before July, or which one? July comes first.
Or that time my petition pending lordship. Sorry. That time my
Come to page 40.
Yes, lordship.
Page 40 is the judgment in your case, isn't it?
Lordship, lordship.
Order date is 16/7,
Lordship.
2025.
Lordship.
And that series of cases was just disposed of on 3/4/2025.
Lordship.
Correct.
Lordship.
So your case is that your case is not pending. It was rejected by the DLC.
DLC.
So you challenge that
I
by
challenge that.
filing writ
Lordship,
petition.
yes.
But the court find no merit. It was dismissed.
Dismissed lordship. Now
So what is the cause of action now?
there is no cause of action lordship. The thing is that I filed
How
a
do you file this writ petition then?
I filed a representation on 8/12/25 lawsuit, partial to notification lawsuit. Page 17 lawsuit.
8/12 you filed.
Lawsuit.
The
That
last
may be-
date,
That may be the direction we made to
no,
dispose
no,
of.
no.
That is my.
The last date was what?
The last date that another IA was filed by the government seeking three more months time lawsuit. Government seek and file an IA that's it.
3 more months time for what?
Verification only.
Verification of the lawsuit.
No. You are supposed to submit your particulars within a particular date.
Lawsuit.
30,
What is the date?
25 lordship.
What is the date?
15/9/2025.
Where do we find that?
And notification.
Certain notification.
You should at least the next legible copies you see. I don't know how they,
15/9/2025 lawsuit.
where do you find that? Where can we see that date? Page number?
At bottom, page 72 at bottom lawsuit. 11 lawsuit, at bottom lawsuit, 11.
On or before.
On or before 15/9/2025.
Then you file your representation on
Because I have
8/12.
no knowledge at that time lawsuit
So-
regarding this passing of this notification.
You have missed the bus.
I missed the first lawsuit.
No, you have missed the flight. Bus though you can catch. You hire a taxi and chase the bus. But flight, how will you catch the flight now? You have missed the flight.
Lawsuit, one similarly person also approached before this court lawsuit
And what happened?
in the page 77 lawsuit. Page 77. And his writ petition was disposed of 5/12/25 lawsuit. The kindly place page 80 lawsuit.
Is
Page
it-
80 lawsuit, para 4 lawsuit.
Is it similar to your case?
Now, he's also the petition has been dismissed by DLC. Then
Date of
there's
filing
approval
of
honorable court.
application has been extended by the government till January 2026.
Page 4 lawsuit, sorry, page 80, para 4 lawsuit.
That is what I'm reading.
Oh, yes, lawsuit.
Where is that extension?
Extension is page 75 lawsuit. IA has been filed by the government lawsuit. But dispose of 16/10/25 lawsuit. Ardor learner who pressed 3 months extension to comply the order dated 3/4/25 passed in WPC number 3/4/25 and other link cases with effect from 3/10/25.
This for verification.
And page 7 is the last, according to applicant, government is granted 3 months extension for compliance order at 3/4/25.
That is for compliance of the order.
Compliance, last.
It is not for submitting the application of with containing the particulars. How does it help you?
There was a kindly page 80 loss, months loss.
So court had, in the original order, court had said that the applications for compassionate appointment should be disposed of by the concerned authorities on merit as they deem fit and proper. The decision be taken
Within 6 months.
Where's the time frame?
Lordship. 6 months given, Lordship, in the
Where?
original order, Lordship.
Where? Come to page 62.
Page 62, Lordship.
Where is
Sorry, page 61. 9, para 9, sub para 2, Lordship. 61, last, the entire process for considering the various applications for compassionate appointment, the decision to be taken in each case by next paragraph.
correct? Said 6
But-
months.
6 months.
So according to the government, 6 months was too short. They
Short.
wanted extension for 3
Extension was-
months. So extension was granted to complete the process.
Last.
But this extension is not for submission of the particulars. So how will it help you?
That's right. Now, the representations that have been filed by me on 8/12/25, that must be made a direction to dispose of on merit losses. That's my question. By the department losses.
Twelve, 23. What is this 12/12/23? Can you show me what is this 12/12/23?
Lordship.
Order of the court dated 12/12/23, which is reflected in page 81.
Yes, Lordship.
What is that?
That of page 81, Lordship. Also considering facts and circumstances record, and also as agreed upon, the court is inclined to dispose of this petition by directing respondent to consider representation of the petitioner filed on 25/11/25 and to place the case before appropriate court pursuant to order dated 12/12/20 in abbreviation of 596023, Lordship.
What is this 12/12/23?
This order,
Where is this order?
this order passed by, this one on behalf of this person, Lordship, the another person, Lordship. Anis Kursid Alam, Lordship. He had approached before this court by this petition, Lordship. Page 79, Lordship, para 3, Lordship.
Para 3.3. Para 3.2.
Lordship, page 78, last para 3.2, Lordship, and last para 3.2, 78, Lordship, page. There, DO had placed the proposal of petitioner before the district level committee, and its meeting held on 22/9/21. The same was rejected. Being agreed, the petitioner had approached this court by filing a writ petition being number so and so, praying for settings a DLC meeting, DLC minus of the meeting dated 22/9/21.
So here lies the difference again.
Yes.
In the other case, court took note of the fact that the rejection of the DLC was set aside, remanded back to
DLC,
DLC.
yes.
Despite that was not done, Ultimately, because of those series of cases, the petitioner belatedly filed her particulars, his particulars. Then court says that no, you consider that stressing on the order dated 12/12/23, because there was already a direction. In your case, there is also a direction, but this is dismissal direction. So you're not covered.
I am not covered. Lordship, now my only prayer, Lordship, that I have filed after.
So how do we direct the court? How do we direct the authorities at this stage now?
No, my only prayer, Lordship, the representation that had been filed by me on 8/12/25. That may be that I have stated everything, Lordship. That may be direction to dispose of the representation, Lordship. That's not merit,
8/12/25.
Lordship. Page 73, Lordship, Annexure 13, page 73.
So that you will get some ground to come back to the court again.
Not
Huh?
on merit, Lordship.
On merit, what do you mean on merit? You see your representation, it says prayer for allowing me to submit the detailed particulars as per notice dated 30/8/2020.
25, that is notice, Lordship.
This was submitted on 8/12.
8/12, Lordship, because in the application I have stated why I'm delayed the filing of this representation, Lordship.
Ms. Kowar, what do you say?
A verification process is about to conclude at Lordship. So at this stage, this prayer cannot be allowed. Lordship.
No, his prays only to consider this representation, that's all.
But
you may allow it, you may reject it also, we don't know.
yes, Lordship.
In a rejected word. That must be Lordship.
Personal department can DLC can the personal department can allow
Heard Mr.
KD Sharma.
KD Sharma, learned counsel for the petitioner, and Ms. S. Kowar, learned standing counsel, Elementary Education Department.
I'm for government Lordship, 1,
I'm sorry.
2, and 6 Lordship.
Learned government advocate for the state respondents. Anyone else? No.
Yes.
And Miss N. Fukan for the elementary education, elementary education department. Stop having regard to the grievance projected by the petitioner. The writ petition is taken up for disposal at the motion stage itself. Next para. The petitioner's father. No, cancel that. It is the case of the petitioner that his father died in harness on 29/3/2008. And who submitted the application?
My mother applied on behalf of me.
When?
Immediately, Lordship.
Then what happened to that?
Applied on 12/5/2008, Lordship. I applied on 12/5/2008. That is, I have stated in the representation, Lordship.
Your mother applied for herself or for
No,
you?
but for on behalf of me, for me, Lordship.
Why couldn't you apply yourself?
She applied for me, Lordship.
No, why couldn't you apply for yourself? You were underage or what? Huh? And the petitioner's mother submitted an application for compassionate appointment. Of the petitioner on 12/5/2008. So since the application was not considered, the petitioner approached this court by filing WPC number 5093 of 2009. Stop, the writ petition was disposed of by order dated 2011-2009 with a direction to the respondent authorities to consider the case of the petitioner in terms of the relevant guidelines. Stop, the case of the petitioner was considered by the DLC, which met on 17/8/2011, but his application was rejected. Stop, the petitioner then initiated his second writ petition by filing WPC number 5888 of 2023, challenging the DLC minutes. Stop, the writ petition came to be dismissed by judgment and order dated 16/7/2025. By taking into account the decision of the apex court rendered in state of West Bengal versus Debarata Tiwari and others, reported in 2023 SCC Online SC 219. Stop, despite the dismissal of the writ petition, the petitioner claims that the office memorandum dated 18/9/2024 issued by the Personnel (B) Department, Government of Assam, was put to challenge by a number of similar situated persons. Since the compassionate appointment scheme was notified to be not applicable for those employees who died in harness on or after 1/4/2017. In view of the introduction of the compassionate family pension scheme, in lieu of compassionate appointment, stop, all the pending writ petitions challenging the office memorandum were taken up together and disposed of by common order dated 3/4/2025, with the lead case being WPC number 342 of 2025, by directing the respondent authorities to consider the case of all pending cases for consideration in terms of the relevant scheme. To stop, acting upon the said direction, the respondent authorities had issued a notice on Date of notice,
30/2025.
38/2025.
38
2025.
2025, requiring all interested persons to submit their detailed particulars for considering their case for compassionate appointment on or before 15/9.
15/9/25.
15/9/2025. Stop. According to the petitioner, since he was not aware about the notice, and on coming to know of the same, he could submit his details only on 8/12/2025. Bracket annexure 13. Stop. Since there was delay in filing his detailed particulars, the petitioner now apprehends that his case will not be considered by the respondent authorities. Stop. It is for this reason that the petitioner has filed the instant writ petition. Stop. The learned counsel for the petitioner submits that the limited prayer of the petitioner is that the representation submitted by him. This is not representation. Is it representation?
Lordship.
Huh?
Lordship. Filed before the personal department, Lordship. Yes, 74.
73.
Yes,
Representation
70.
submitted by him on 8/12/2025, bracket annexure 13, be directed to be considered by the respondent authority. Next para, having regard to the above, the writ petition is disposed of by directing the respondent authorities inside. Is he a party here? Secretary? Bracket respondent number 2. To consider and dispose of the representation submitted by the petitioner on
8/12/20.
Eight 12/2025 on its own merit without on its own merit, I said, on its own merit. Without being influenced by any observation which may have been made here and above. And the same should be done within a period of
1 month, Lordship. 1 month.
2 months from the
Of the
date
date
of
of
receipt of a certified copy of this order.
Order copy. From the date of submission, the order copy, Lordship.
Yes, from the date. Next time, don't bring this kind of case.
Lordship.
I was about to dismiss. Okay.
For orders, item one, bail application 56 of 2025 pertaining to Aizawl Bank.
Hello.
Oh,
Your
you're
Lordship.
here. You're appearing physically.
Yes, my lords. I
Good.
practice here, so I had the
Okay.
convenience of appearing from here today.
Okay, okay. Yes.
Your Lordship. Appearing on behalf of Ms. Vanessa, Additional Public Prosecutor, I
Oh, you're there,
must.
okay. Yes.
Yes, Your Lordship, I respectfully seek an adjournment as she is presently engaged in a hearing before the Honorable Division Bench.
Mm.
So I humbly pray that the matter be taken up next week.
My lords, this is a whole pending matter, my lord. It's already behind bars for 2 years, 8 months now. And my lord, we have the arrest memo on record wherein the grounds of arrest were not served. My lord, there is some urgency, my lords.
That was never urged earlier.
My lords, on the last occasion, the notice was issued to the learned PP. So
No, no. When you moved the bail application in the year 2024, there was no occasion for you mentioning that grounds of arrest is not given to me.
yes, my lords.
Now, after that judgment of that Vihar and all
Yes.
that, you come
Yes.
up with this kind of plea.
My lords, that
That
was,
will have to be considered.
of course, my lords. My lords, perhaps a short accommodation is perhaps it's desirable, but if it's a long date, my lord, it would be very problematic for us.
Next week,
Yes, my lord.
My lord, on a fixed date, if I.
definitely. Please write. Ms. Vanessa, learned additional public prosecutor, who is supposed to appear through RVC, is said to be engaged before a division bench of the Aizawl bench of the Guwahati High Court. And therefore, an adjournment prayer has been made on our behalf by Miss, your good name?
Lasang Zeli.
Lalsang Zeli, LLSANGZELI.
Yes, Your Lordship.
Then, as prayed for, let the matter be listed on
27th, my lord, if it pleases.
all right, 27.
Yes, Your Lordship.
27 January 2026.
Doubly obliged, Your Lordship.
My pleasure, Lordship. Lordship, here I am with a very limited prayer, Lordship, since the matter, since the issue involved in this matter has already been decided by this honorable court, Lordship. Lordship,
What matter?
Lordship, I'm going to that, Lordship.
So many matters have been decided by this court.
Lordship. Very
Which matter?
recently, a judgment has been passed, Lordship, and that judgment covered my matter, Lordship, this matter, Lordship. Lordship, the fact is that.
Yes, please share us the subject matter.
Yes.
Simply saying covered matter, we don't know what is
Subject
covered.
matter with regard to one common termination order. One common termination order issued in the year 2001, Lordship. The fact is that, Lordship, in the year 1996, Lordship, an advertisement was issued, Lordship, for appointment of teachers, Lordship. But due to ban imposed on the state, Lordship, process could not be completed, Lordship. Then, Lordship, a scheme was launched in the state of Assam, Lordship, namely, Lordship, Operation Blackboard, Lordship, OBP, Lordship, and created, Lordship, 7,066 posts, Lordship. Out of this post, Lordship, 140 posts were allotted to Nalbari district, Lordship. And that was created on 8/3/2001, Lordship. Creation letter is at place, Lordship, 18, page 18, post creation letter. Post creation letter, page 18. Lordship.
Yes, go on.
Total for LP school, 280 posts, and for middle middle school, lordship, 135 schools, teachers, lordship.
You're referring to which district?
Lordship, Nalbari district. I'm
Nalbari.
from Nalbari district, lordship. Then, lordship, a WT message was issued to all district elementary education officers, lordship, to appoint the teachers, lordship, as selected by the subdivisional advisory board, lordship. This is the WT message is that as at page, lordship, 20. Page 20, lordship. And accordingly, lordship, followed by this WT message and lordship, following the select list prepared by the subdivision level advisory board, lordship, petitioners were appointed, lordship. Some petitioners, lordship, annexes C series, lordship, page 24 onwards, 24 to 43, lordship. 24 to lordship, 43, lordship. There are, lordship, all total.
What are you
30
seeking?
numbers,
What
30
is your prayer?
Lordship, I'm going to that, lordship. Then, lordship, what happened? And accordingly, lordship.
No,
we
you
do it.
show me your termination order, 21-7.
Termination order is
Can't
at
go
page
like that.
74, lordship.
Huh? Page
74. Termination order is at page 74.
74.
74.
You're challenging this?
Lordship, this is, lordship, yes, lordship, 74.
74.
74. This is a common termination order.
Correct.
By
You are also included.
lordship, all teachers were terminated, lordship.
Yes.
Challenging that order, lordship, several writ petitions were filed before this honorable court, lordship. Amongst other, lordship, lordship, one, I have a next, that is at page 78. 78. This case was disposed of on 4/12/2001.
So why are you coming in 2026? After...
I'm going to that, lordship. I'm going to that.
No, you go to that now only.
Yes, Lord. No, subsequently.
You are saying that similar case was taken up and
Yes.
disposed of in
Yes.
2021.
Yes, yes.
2001.
I'm going to have lordship, sometime will be required to me, lordship. 78, lordship, is the
No, we don't have that much time, Mr. Counsel.
judgment
Please
passed by
speed up.
this court, lordship. Relevant parties, lordship, 82, page 82. This is the initial judgment. Where we are also the parties, lordship, petitioners. Paragraph number 14. In view of what is stated above, this court considered that it would be appropriate to dispose of the writ petition with a direction to the state government to initiate an inquiry for it to be completed within 15 January 2002 in order to determine the genuineness of the select list referred to above and identify the candidates who were genuinely selected and allow them to join their respective schools as per appointment letters issued earlier and cancelled by the impugn orders. This was the initial order, lordship.
Yes.
Then, lordship, I am going to place your lordships. Another one judgment, lordship, which is at page, lordship, 100, lordship. This order is important, lordship. Page 100, lordship. Page 100. Relevant parties at page, lordship, 106. 106, lordship. 106. Yeah, lordship. Paragraph number 11, lordship. Accordingly, for the reason discussed above, the present petition is disposed of, directing the respondent authorities to publish the report of the committee constituted height notification dated 8/2/2016, and thereafter the state government will take a reasonable decision on the basis of such report submitted by the aforesaid committee in terms of the direction issued by this court earlier on 4/12/2001, which I have already, lordship, placed before your lordship, and others. As these matters are pending for a long period, lordship, since 2001 till the order passed on 4/12/2001, issue was not, lordship, decided by the state, lordship, and accordingly, lordship, some petitioners approached before this court in the year 2017, and accordingly this direction, lordship, 19/9/2019, and followed by, and lordship, complying that order, lordship, an order was passed by the authority which is at page 113. 113.
Yes.
113, which negates the claim of the petitioner, lordship. Petitioner and others, lordship. And this order was challenged, lordship, again before this honorable court. And lordship, after a length of hearing, lordship, issue has been decided by this honorable court, which is at page, lordship, 117, and except P, lordship. And we are similarly situated to those petitioners, Lordship, Kamal Chandra Das and four others. They were also terminated with the common termination order, Lordship. We are also, Lordship. This, our case is covered by this judgment, Lordship. Judgment, your Lordship, relevant part of the judgment is at page, Lordship, 107.
Which judgment?
Lordship, I'm going to that, Lordship. Paragraph number 35.
No, which
35,
judgment is that?
Lordship, paragraph number 35.
Page?
Page, Lordship, 136.
Judgment in which case?
Last Judge Kamal Chandra Das and four others. NXRP page 117.
You are also the petitioner there.
I am not the petitioner. That is why, Lordship, I approach. We are similarly situated.
No, similar situated how? You are fence sitter. You know fence sitter.
No, Lordship.
You are watching the show.
No, Lordship. On different.
Waiting whether relief will be granted or not.
Lordship, yes, Lordship. To that effect, Lordship, there are some findings from the Honorable Supreme
First of all, you tell me what is this page 115?
Lordship.
This is the original copy of the order.
Lordship.
Page 115.
115. 116, Lordship, paragraph number.
This is the rejection order.
Yes, 115 is rejection.
Then after this rejection, what happened?
Lordship. This is page 113, Lordship, 113.
Correct.
113, type copy is 113, Lordship.
Same
This is the
thing.
impugn order.
Same thing.
Yes,
Type
yes.
copy original
Yes,
order.
yes, this is the impugn order.
After that order, what happened?
After that order, some petitioners approached this honorable court, Lordship.
By filing
Lordship,
annexure P.
Yes, annexure P, Lordship. And that order was set aside, Lordship. This annexure O was for all the terminated teachers, Lordship.
Was
This-
set aside.
Yes, for the annexure O affect
What?
all the terminated teachers.
Where is the relevant portion?
For in judgment, Lordship. In judgment, Lordship, 11% 35, paragraph number 35, page 136. 35,
35.
Lordship. This is in WPC number 2933/2017, along with WPC number so and so, was finally disposed of by judgment and order dated so and so, directing the respondents to publish the report of the committee.
No, that I've read. I'm asking you the operative portion.
That's it. This is relevant also.
You're showing me from the middle.
And
Show me the
it-
operative portion.
Yes, operative order also on this, Lordship. Lordship, paragraph number 41, 42, 43. Paragraph number 35 onwards are observations, Lordship, of courts or observations.
Yes, any appeal filed? Any appeal?
My lord, I have to take instruction.
Ah.
My lord,
Now,
this is-
were you a part of any of these proceedings?
Yes,
In which case?
in Lordship, yes, Lordship, I'm going to tell Lordship, annexure K, page 91. Annexure K,
91.
yes, K, page 91. Just I have. All the petitioners were a part of this proceedings, Lordship. 3961/2003.
No, page 91.
3961/2003,
Page.
page 91. Page 91.
'91.
And somewhere also, Lordship, parts of Lordship, WBC number 6469 also, Lordship. But all are in
No, you are a part of this in the page 91.
91,
Case number,
page number 91,
case number.
case number 3961/2003.
Thereafter, what did you do?
The thereafter, Lordship, process was going on, Lordship. No order was passed till date, Lordship. Finally, order was passed in the year 2020, Lordship, on 19, Lordship.
Now-
June 2020. Cause
What-
of action started from 10 June 2020.
You were not a part of that case filed in 2017?
Somewhere, Lordship.
Somewhere?
Somewhere, Lordship.
Who?
Lordship,
Which one?
actually, what is there? This case was dealt by one Lordship association like that, Lordship. Since all were affected, Lordship. Some people only, Lordship, silence, are taking the responsibility to silence the orders, Lordship. But Lordship, I am clear enough that all the petitioners, to some extent, Lordship, are involved with courts proceeding, Lordship, earlier.
Which case? 3961?
Yes, not only in 3961, Lordship, but in 3961, Annexa K, Lordship, in Annexa K, all the petitioners were the petitioners, Lordship.
And subsequent petition?
Thereafter, Lordship, cause of action started only in the, only on Lordship 10 June 2020.
No, don't dilute what I'm asking you.
Lordship.
I'm asking you, when did you take part thereafter? 2003, you have filed a writ petition.
Lordship.
2017, are you a
Lordship, our
amongst the
association-
petitioners?
Actually, there are some associations, Lordship, terminated teachers association. They were approaching or Lordship, taking the responsibility, Lordship, to silence. They are approaching, Lordship.
So the answer is no.
No, Lordship.
So say that. Don't give excuse. You are not a party, so I am not a party. That's all. So since 2003, you have been watching the show. Suddenly in 2020, somebody filed a petition in 2017. Matter was disposed and you became active again. This is the picture I'm getting. Anyway, today we're not saying anything. We will issue notice.
Same petitioners, 2017 case, the petitioners who is there in 2020, same petitioners are there.
Who?
Petitioners of the case of the 2017, madam. They are the same in the 2020 case, madam.
And today's petitioners,
They are different. They are not in.
They're
this.
different.
You are
That's
not
what-
in the.
That is what I'm saying. That word fence sitters.
True, madam. They are pensioners.
Lordship.
Since 2003, they are sitting there.
You are similarly, you have similar cause of action, but you will do nothing. You will just wait and watch. Let us see what happens.
Lordship.
If they succeed, I will also jump it.
Lordship.
So that is not permissible.
Lordship, but Lordship, in one case, Lordship, the Honorable Supreme Court, Lordship, with regard to Lordship, delay lessons and Lordship parity. It is a clear finding from the Honorable Supreme Court, Lordship.
Likewise, there's
in the
another
case
case
of-
also which says
In the case of
court
Lordship,
should not encourage fence sitters to come like that.
Lordship,
Anyway, heard Mr.
Talukdar, Lordship.
Talukdar, learned counsel for the petitioners, who submits that the petitioner is aggrieved with the order dated 21
10 June 2020, Lordship. Impleadment order is 10 June 2020. Page 113.
113.
113, page 113.
Okay, aggrieved with the order dated 10/6/2020, bracket annexure O. But come to your prayer portion.
I have not challenged, Lordship. Now, this time I only, Lordship, pray for a common order, Lordship.
Here will be praying for recalling the.
Recalling the termination order. Termination order in it was on, Lordship, 21st June 2001. In the subsequent judgment, Lordship, termination order and the subsequent order always set aside, Lordship.
Which is set aside? What is set aside?
All orders were set aside. Termination order, including termination order.
Including this 21/3/2001.
Yes.
Then why are you praying for recalling the order after if it's set aside?
Set aside, Lordship.
You want it to be set aside again? Second time?
No, Lordship.
Then?
Lordship, already set aside, Lordship.
If it's already set aside, then why are you praying this? Recalling?
Lordship, that order was to Individuals, Lordship. Few petitioners,
I
Lordship.
don't know what you are praying for. Please rewrite again, that Mr. So-and-so, learned counsel for the petition, who submits that by filing this writ petition, the petitioners have sought for recalling the termination order dated 21/7/2001. Bracket annexure I. By which all appointed assistant teachers of ME/MV/ME Madrasa senior basic schools made by the in charge DEEO Amulya Chaudhary with effect from 1/3/2001 were cancelled with immediate effect. This order was interfered with by which order?
Lord, Annexure P, Lordship.
Annexure P.
Annexure P. Annexure P. Lordship.
11 portion.
Paragraph number, Lordship, 42. Lordship. 42 and 43, Lordship. Directed to reinstate.
It's not reinstatement. I'm asking you about the setting aside of this order. Where is it?
Lordship, paragraph number 41, Your Lordship, paragraph 41, 139. In my view, there has been a mere inaction on the part of the respondent authorities to segregate the genuinely selected and appointed candidates despite ample opportunity and availability of records. At this distant point of time, after multiple litigations, queries, and various directions of this court for consideration of the matter, a rejection of the claim of the petitioners on the ground of difficulty to segregate the genuine candidates, and more than 24 years have elapsed since the selection in 2001, during which time significant changes have occurred in the educational and professional qualifications and eligibility criteria for appointment as teacher, assistant teacher in LP and ME schools on the pretext of enactment of right of children to free and compulsory education act 2009 would be unjustified and thus unsustainable. Paragraph 42, in view of discussion made herein above, I am of the considered view that the impugned decision and order dated 16/5/2020 and 10/6/2020, Lordship, by this order, Lordship, earlier termination, Lordship, common termination was upheld, are unjustified and not sustainable. Accordingly, the impugned decision and order dated so and so are hereby set aside and quashed. Considering all the orders, including cancellation of appointment orders, are set aside, Lordship. Not specifically mentioned, but including cancellation of appointment orders. These appointment orders were cancelled, Lordship, by the common termination order, Lordship, in the year 2001. As a result, the petitioners are entitled to be reinstated in service as teacher of LP and ME school in the district of Nalbari in terms of the selection and appointment made pursuant to the advertisement dated 28/12/1996. Accordingly, the responding authorities are directed to reinstate the petitioners in their services without back wages, following the principle of no work, no pay, however, with seniority and other entertainments as may permissible under the law. Lordship, all the petitioners have, Lordship, not more than, Lordship, 2-3 years of services, Lordship. Only that must may be granted. They will not get any benefit, Lordship. Wages, back wages, Lordship. Only 2-3 years service will get.
That is if you succeed.
Lordship, your Lordship
If
may
you don't
kindly,
succeed, you will not get anything.
Lordship may kindly come to the page number 4. Petitioner number 1 is 55 years.
No,
Lordship.
don't show me all that.
One is lordship 58 years. And they will not get any arrears or back wages, lordship.
You have come to the court through WPC number 6469, is it?
Lordship.
Let us see the names. Gitanjali Kalita Barwa. Who is petitioner number in this case?
That's it.
Is not there.
That's it.
Which was your writ petition earlier?
My admission, lordship.
Yes.
Okay, annexa K, lordship. Okay,
Only
annexer-
order is there. man.
Only order, but I am sure, lordship, all the petitioners were included in this writ petition.
Oh, annexer K page number.
Page number 91.
Paramesh Rajbangshi.
Paramesh Rajbangshi. Paramesh Rajbangshi and others.
His petition number
Lordship 3961 of 2003.
in the present writ petition, is he a party?
The Paramesh Rajbangshi is not,
Then-
but other petitioners are the party, lordship.
How many petitions were there?
Lordship, lordship, more than hundreds, lordship, more than hundreds.
Stop. Please write, according to the learned counsel for the petitioner, the present petitioners had earlier approached this court along with others by filing WPC number 3961 of 2003. And the writ petition was disposed of by order dated 24/6/2003 by directing the respondent authority to examine and verify the claim of the petitioner and upon such verification, if it is found that they have been appointed by the competent authority against the sanction post, an existing vacancy, and rendering service as was being claimed, necessary orders for releasing the pay and allowances should be passed within a period of 3 months from the date of the receipt of the order of the court. Stop. The learned counsel submits that despite the same, the respondent authorities did not take any steps which persuaded similarly situated persons to file WPC number 2651 of 2017. So the writ petition was disposed of by order dated 19/9/2019 by directing the respondent authorities to publish the report of the committee that was constituted and thereafter to take a decision on the basis of the said report in terms of the court's earlier order dated 4/12/2001. Passed in WPC number 6469 of 2001. Stop. Acting upon the said direction, the claim of the said petitioners who are also similar situated as the present petitioners came to be rejected by order dated 10/6/2020. Bracket annexure O. The said order was put to challenge in WPC number 5641 of 2020. By the petitioners in WPC number 2651 of 2017. And the writ petition came to be allowed by judgment and order dated 2/12/2025. Bracket annexure P. Of the learned counsel for the petitioners submits that as the present petitioners are also similarly situated, they are covered by the said decision. And the respondents should be directed to grant the petitioners similar benefit. Stop. Next para. From the above projection, it is seen that apart from filing WPC number 6469 of 2001, the petitioners had not pursued their case like other similar situated persons. And therefore, question is as to whether similar relief can be granted to persons who can be termed as fence sitters. Stop. Be that as it may, the said question will have to be answered at the appropriate time. Next para. In view of above, issue notice of motion returnable by 4 weeks. Mr.
I am for 124, man, PK Bora.
PK Bora, learned counsel for the elementary education. Accepts notice on behalf of respondent numbers 1 to 4.
1 to 4.
And Miss S. Kaur, learned government advocate. Accepts notice on behalf of respondent number 5. Notice is complete. Petitioners to serve extra copies of the writ petition to the learned counsels appearing today within 2 days. List again after 4 weeks. On so and so. Give a date.
Bless.
Wait, that was 11. 11. 10 is over. 10 is also over. Yes, yes.
So this is my lord regarding non-payment of family pensions. Petitioner before your lordship is a widow lordship. Her husband was died in the year 2003 while he was in service lordship. Lordship, kindly come to the page number 19. These are my factual position. Page number 19. The Director of Elementary Education has processed the pension file, Lordship, is lying before the Director of Pension, my lord, but not yet released the family pension as well as the other retirement benefits to the petitioner.
What is page 19? Tell me.
Page number 19, my lord.
Yes.
On the basis of the submission of the report from Dhemaji Bhai, turn number so and so, dated so and so, that let Sabhi Bhushan Gogoi, that is the husband of the petitioner, expired 80 of the Hatingao LP School under BO Dhemaji of the Dhemaji district, was appointed as a stipendiary teacher on 19/1/1994. Thereafter, he was deputed to the JBT training during 1999. As per order issued by the director of the SCRT Assam, dated so and so, were declared pass JPT on 27/7 in 2000. Finally, the incumbent was died on 21/2/2023 Lordship, during his service period. In view of the above, let Sami Bhushan Gogoi expiry of so and so BU Dhemaji of Dhemaji district is hereby posthumously allowed to draw the scale pay from passing of JBT with effect from so and so till his death, Lordship. Accordingly, the DU Dhemaji is hereby instructed to take necessary steps for release of family pension against let Bhushan Gogoi, expired 80 of Tigor LP School under BO Dhemaji of Dhemaji district under Assam service pension rules. Therefore, Lordship.
What do you understand by this? Language is very difficult to understand.
Lordship, while the petitioner, my lord, husband of the petitioner was deputed to junior basic training in the year 1999. One, my lord, his child was, my lord, withheld, my lord, due to he was non-appeared in the practical examination. However, subsequently, my lord, his child was declared, my lord, in the year Lordship 2004. By that time, my lord, he is died, Lordship. At page number 18. Page number 18 is the, my lord.
What was he?
He was
assistant teacher.
Yes, Lordship. Yes.
Then he was deputed to undergo junior basic training.
Lordship. He is passed, my lord. But my lord, child was withheld, Lordship, due to his he was not appeared in the practical examination. Subsequently, my lord.
What was withheld?
My lord, page number 18, my lord, it will clear, Lordship.
No, what was withheld? Tell me.
My lord, child of the husband of the petitioner. Husband of the petitioner. Result. Junior basic training results. Although he was passed.
Withheld.
Yes, Lordship.
Because he did not appear for the practical examination. Then,
Lordship.
Before results was declared, he died.
Yes.
He died on 21/2/2003.
Yes, Lordship. Page number 18 is the clear. On the basis of this order, my lord, director has passed, my lord, page number 19.
What is page number 19?
19 is the passed by the, my lord, director of elementary education. This is the order.
He is hereby instructed to take necessary steps to release family pension who expired as so and so.
Accordingly, my lord, pension is processed, my lord, page number 28 by the, my lord, BO.
If it's processed, then why are you here?
Lordship. Page number 29, 28 and 29, my lord. My pension is processed, my lord. But not till then, my lord, not released, Lordship.
Where is it stuck up now?
Lordship.
At what stage is it stuck?
Lordship, it says, my lord, my
You are
spending before
you are saying that it's under process.
Yes, Lordship.
If it's under process, is it not premature to come to the court?
No, my lord. Is last on, my lord, 24/9/2025, my lord. Not released. Petitioner husband died in the year 2003, Lordship.
And you come in 2025 or 26?
No, my lord. File is processed, Lordship. So, my lord, at this age, still, my lord, I pay for only notice to the
No.
authority, and my lord, in the meantime, my lord, provisional pension may be released, Lordship. Last 23 years, my lord, without. Let them take instruction, Lordship.
No, please explain your case. I have not understood till now.
Lordship. Husband of the petitioner.
Annexure D says that the Who is this? Director Elementary
Director.
Education.
Like directors
He has directed the DEEO Dhemaji to
process.
take steps for release of family pension.
Yes, Lordship.
Now, what is the steps to be taken?
Lordship, at page number 28.
28.
Yes, Lordship.
Yes.
They have processed, Lordship. They forwarded the pension proposal to the my lord DI school Dhemaji, Lordship. And upon receipt of the proposal, Lordship, the DI school, my lord DO forwarded to the director of pension, my lord, on 24/9/2025, Lordship, page number 29. Page number 29.
29.
29 my lord, is the my lord, final. This is my status.
So proposal submitted sometime in September last year.
Yes.
So you have to wait for some time. Your writ petition seems to be premature.
Not premature, Lordship, not yet my lord, release any pilot. At least my lord, provisional pension may they may be released, Lordship. Final pension will release my lord later, Lordship. At least provisional pension, Lordship. Whenever receive my lord the pension proposal, my lord.
No, husband died in the year 2003. You are coming in 2026.
No, my lord, they have processed, my lord. Kindly see the order, my lord, page number 19, my lord.
They are processing, let them process.
My lord, that is their fault,
So
Lordship.
you
not
wait.
my- That is their fault, Lordship.
It is their fault, but they're processing it. You also waited.
Lordship.
You have to wait for some more.
Lordship, my lord,
Can they do it overnight?
No, my lord. I'm
Then-
entitled, my lord, provisional pension at least, my lord.
That's
I'm
a different
waiting
thing.
for the final pension. I will wait, my lord. At least, my lord, provisional pension may be granted, Lordship. I'm ready for wait, my lord, to the final pension.
Do you accept or not
Lordship.
that you have come after so many years?
No, my lord, they have processed, my lord, in the year 2025.
What were you doing from 2012, 2003?
I have represented to my lord.
Where is your
before the Lordship.
representation?
No, no. By verbally, Lordship. I have
More than 20 years you are waiting.
Therefore, my lord, this, my lord, this
And
order.
suddenly you say that you are in a hurry. What kind of,
No, my lord, I am not seeking, my lord, regular pension, my lord, till today.
don't
Lordship.
seek anything right now.
My lord, at least provisional pension may be released, Lordship.
You're not, I mean, you're not accepting that you're coming after 20 years. And you're saying release
My lord,
something to
since
me.
my lord, file is processed, my lord. Accordingly, my lord, this order is come,
If
Lordship.
file is processed, then you wait. If not processed, then you come. If it is processed, then why you will come
Provisional, my
before
lord,
the
regarding
court?
provisional pension, at least, my lord, as an interim measure. Final pension, my lord, I will look into.
Yes. Anyone for the other side?
Provisional pension can be released, Lordship.
Lordship, the petitioner, otherwise as he has drawn the attention to 29 that and now since he has prayed for his provisional pension, your Lordship, her provisional pension, your Lordship, the processing authority, that your Lordship, the department, they will grant the same, your Lordship.
No, if you see the
Whether
documents,
petitioner had preferred the same for praying for the provisional pension, your Lordship, that doesn't reflect.
okay,
Yes.
there's a prayer made in the writ petition. You see, after seeing all these documents, letter has been written to the director of pension now. What further process is required?
Gradually, it will, your Lordship, proposal will be carried out, your Lordship.
From the department, my lord, it has been sent to the director.
And the department,
Director of pensions, who's appearing?
director of pension, me, your Lordship.
Oh, you are appearing.
Yes.
After receiving the pension papers, what do? What is the process?
Lordship, after obtaining the necessary, all of the particulars,
They have sent you.
yes.
It's Annexus G. They have sent you.
Next, page number
29.
Yeah,
29.
G. Yeah. So
To process the pension will take time or what? How much time does it take?
Around 4 to 6 months, Your Lordship.
What is the process?
After obtaining all of the necessary particulars, Your Lordship, they will match it and again further seek for the necessary queries from if they require, Your Lordship.
Okay, please write. Hard,
It's
Mr.
4-month bonus.
Hard, Mr. D. Gogoi.
D. Gogoi, sir.
Learned counsel for the petitioner who submits that the this is the wife, isn't it?
Yes, yes.
Husband of the petitioner died in harness on 21/2/2003. And since then, no pension has been provided to the petitioner, who is the wife of the deceased employee. Stop the learned counsel submits that the necessary particulars and documents that was requisition from the district elementary education officer, Dhemaji, has already been forwarded to the Director of Pension, Government of Assam, on 24/9/2025, bracket annexure G. But despite the same, pension of the petitioner has not been paid till date. Stop the learned counsel therefore submits that the respondents be directed to grant family pension as entitled to the petitioner within a time frame, and pending the same, provisional pension be given to the petitioner. Next, para in view of above, issue notice of motion returnable by 3 weeks. Mr. B. Diori, Learned Government Advocate, accepts notice on behalf of respondent numbers.
I'm for respondent number 6, Your Lordship.
Respondent number 6. While this Learned Standing Council, Elementary Education, accepts notice on behalf of respondent numbers 1 to 5. Notice, yes. Notice is therefore complete. Extra copies be furnished to the Learned Councils appearing for the respondents today within 2 days. On the next returnable date, Mr. B. Diori, Learned Government Advocate, shall obtain instructions and inform the court the process being undertaken by the Director of Pension pursuant to the communication dated 24/9/2025, bracket annexure G. Stop. It is also made clear that the finalization of the pension payable to the petitioner is going to take time. The respondents will not be precluded from granting provisional pension to the petitioner. That may be entitled to her. in law. Yes.
One aspect will lie, Your Lordship, that is the minimum period of regular service that he has done for SARP, Your Lordship. Which was, is required is 10 years, Your Lordship, but he has not completed, so. But
Okay.
still, that since the
But let them
department has
file
sent,
affidavit.
department has sent it,
You decide.
it is the vital issue, otherwise also he will need the rule relaxation for it.
Court has not said that by hook or by crook you give. I'm saying as admissible as
Yeah.
permissible in law.
Yeah.
If you find that the service is lacking, then you will not give. Okay, but get some instruction.
Yes, sir.
Yes, list again on so and so. 26-2.
Please, Your Lordship. My lord, Lordship may peruse page 53, my lord. Relevant portion 54, my lord. What happened, my lord? In this case, I was the respondent in the earlier writ petition. My lord, that private respondent number 7, my lord, filed writ petition. And in that writ petition, this order was passed. What happened, my lord? Though he was given opportunity to file appeal, but he did not file till date. And from 5 years, I have been depriving from receiving any salary.
You are the applicant.
I am the applicant. In that case, I was respondent, my lord, in writ petition. I was respondent.
Respondent number
I was respondent number 7 in the writ petition, my lord.
and writ petition is still pending.
No, my lord, that was disposed of by this order. This order.
You are Rokibuddin,
Yes, my lord.
and that writ petition was disposed of.
That this petition was disposed of with a direction, my lord. That's 2 lines, 54.
Till the appeal is disposed of, interim order dated 12/7/21 us shall continue.
Yes, my
What
lord.
is this interim order?
Interim was, my lord, not to give my lord provincial benefit, my lord. That interim order was, my lord, page 47, my lord. Relevant portion 49. Last line.
Okay.
So what happened, my lord, without salary, my lord, from 5 years I have been depriving, my lord, my college going child, my lord.
Just a minute. Writ petition was disposed of by directing the petitioner to file an appeal. Correct?
Yes, my lord.
And till disposal of the appeal, interim order will continue.
Yes, my lord.
Now, appeal has been filed.
No, my lord, appeal was still the appeal has not been filed, my lord. That is, and therefore the authority did not call me and did not
Okay, now
vacate the order. And he was given only, my lord, 10 days time, my lord.
who was the petitioner?
53.
Name of the petitioner? Nilakanta
Nilakanta, my lord.
Talukdar.
Talukdar.
Is he a party in your IA?
Yes, my lord.
Notice has been served.
No, my lord.
Then
My lord, notice was not issued. Earlier, I have not made him party. Subsequently, I impleaded him as a party.
his respondent number.
Now, my lord, he is respondent number 7, my lord.
Respondent number 7.
My lord, page 4, my lord.
Okay. Notice has not gone.
No, my lord.
So we'll issue notice
My lord.
today. Heard Mr.
M. Hussain.
M. Hussain, learned counsel for the applicant, who submits that in terms of the last court's order, the amended course title has been filed, wherein respondent number 7 has been newly pleaded. Stop. He submits that respondent number 7 was the, no, is the writ petitioner in WPC number 2803 of 2021, by which he had challenged the
Provincialization of service of the
provincialization of service of the
applicant.
instant applicant. Stop. The writ petition was disposed of by order dated 12/7/2021 with a direction to the petitioner to file an appeal before the Secretary to the Government of Assam, School Education Department, bracket elementary, within a period of 10 days from the date of the order. And the said authority, upon receipt of the appeal, was directed to consider and dispose of the appeal after giving a personal hearing to the stakeholders by way of a speaking order and in accordance with law within a period of 2 months from the date of receipt of the appeal. Stop. It was further provided that till the appeal was being disposed of, the interim order not to provincialize the service of the petitioner passed on 12/7/2021 was to continue. Stop. Next para. The learned counsel submits that despite the same, the respondent number 7 did not file any appeal as was directed. And the interim order continues to operate against the petitioner till date. Stop. It is for this reason that the applicant has filed the instant application seeking vacation of the interim order.
Yes, ma'am.
Stop. As the respondent number 7, who is the writ petitioner in WPC number 2803 of 2021, has been impleaded as respondent number 7 recently. Let notice be issued returnable by so and so 19/2. Petitioner to take steps, no, applicant to take steps for service of notice upon respondent number 7 by speed post within 2 days. What about the state, department?
1 to 4 MFA.
Notice has not gone or what? Next para, Ms. S. Sudhir Lanet, Standing Counsel, Elementary Education, accepts notice on behalf of respondent numbers
1, 2, 3, and 4.
1, 2, 3, and 4.
अपना कुछ 6 or 1. The 6 putting on.
There are 4 numbers. Serial number 4 is double at page 2 of your application.
Yes.
Sorry, madam.
No, anyway, you have corrected it now.
3, 4, 5, madam, that.
Now you have corrected in the amended cost
Only
type.
thing, madam, 4 and 5. Thereafter 6. Next page 6 is all right, madam. 1, 2, 3, 4. Next 4 may be given as 5, madam.
Cost title or
No, no, you have amended the cost title. You don't have a copy of the amended cost title, which you yourself have filed.
Yes, madam.
Now things are in order now. I was looking at the previous cost title. In the amended cost title, it's in order. You will not be appearing for the district scrutiny committee.
1 to 5 I am paying, madam. 6 he is.
That's okay for 1 to 6, 1 to 4.
1 to 5.
I'm sorry, 1 to 5. Mr. B. Diori, Government Advocate for respondent number 6. Okay. List again on so and so. You take steps immediately. Okay.
For impleadment, item 14.
Maybe your lordship.
Yes.
That's a petition of your lordship, which a prayer, my lord, to implement the new incumbent, my lord, in place of the original incumbent respondent 1 to 5. So for new incumbent in as per page 6, lordship, I have given the name, address, and a designation, my lord. At page 6, lordship, bottom, my lord, 6, 7, 8, 9, 10. This will be a new incumbent respondent, my lord, in place of the original 1 to 5.
Let them remain 1 to 5.
1 to 5. They are in the resultant vacancy filled up by this new incumbent, my lord. They are maybe transferred. I don't know my reason behind, my lord. The change, man, that has been changed, my lord.
I understand, but let them remain as of now.
I will that may remain.
We'll allow this implement 6 to 10. Hard Mr.
M.U. Ahmed, lordship.
M.U. Ahmed,
Lordship.
Learned Counsel for the applicant who submits that by filing this application, the applicant seeks to implead the new incumbent holding the post of Secretary, Department of School Education, Director, District Elementary Education Officer, Charaidio, Deputy Inspector of Schools, Charaidio, and Block Elementary Education Officer, Sonari. Of the same department as respondent numbers 6 to 10. Stop. The Learned Counsel submits that impleadment of the new incumbents is necessary for effective compliance of the course direction. Stop. Upon hearing the Learned Counsel and on perusal of the materials, on perusal of the application for impleadment of the new respondent numbers 6 to 10 as proposed in paragraph 4 of the application is hereby allowed. Higher stands disposed of. In the main, you write, in view of the order passed today in IAC number 4213 of 2025, petitioner shall file the amended post title in 2 sets within 2 days before the registry of this court, whereafter registry shall do the needful. Next para, issue notice to the newly impleaded respondent numbers 6 to 10, returnable by date 18/2. Petitioner to take steps for service of notice upon them by registered post, no, by speed post within 1 week.
Yes. Obliged.
Matters for orders, item 39.
What was the date you were giving? 18, no? The last line, list again on 18. 18 February.
This is a contempt case of 2014, madam. 9/4/2014 order, my lord, is yet to be complied with.
And item number 39.
39. my lord. The respondent number 3 and 4, my lord, their appointments were set aside. And they're still, my lord, continuing and my lord, getting all the salaries and all. There's a direction to appoint the petitioners, my lord, in place of the my lord, respondent number 6 and 7, 3 and 4, who were the respondents, my lord, 8 and 9 in the my lord writ petition. Page, my lord, 13 is the order.
But why is it listed today for order?
Listed today, my lord, it's been, my lord, it's been listed because, my lord, been coming off and on. And last one, we implemented the response number 8, my lord, because we have changed the, my lord, district elementary education officer, my lord, almost thrice we have, my lord, already, my lord, implemented them, my lord. But the, my lord, main, my lord, response number 3 and 4, they are the persons who were, my lord, illegally appointed in our place. And they're still, my lord, in benefit, my lord, enjoying the benefit, and they don't appear on the case also, my lord. On the last occasion, no one appeared, my lord. Today also, no one is appearing, my lord.
No, thing is that has notice been served to them?
Yes, madam, it was served, they were appearing, madam. They were appearing in this case, madam.
Who is respondent number 8?
Respondent number 8 is the new Miller District Elementary Education Officer, Miller, who was last
Oh.
implemented, Miller.
Our notice has not been served.
It has been served, Miller. 17/3/25, Miller. 17/3, Miller.
Office note of that date, which you just said, 17/3/25. It says that neither AD card nor unserved notice is received back in respect of respondent number 8. Then thereafter on office note dated 24/3 says await service report list after 3 weeks. Thereafter on 7/1/2026 says list the matter on 21/1/26. So there is nothing indicating that notice is complete on respondent number 8. And likewise, 7 also.
Miller 7, of course, he is no longer holding the post, Miller. But more importantly, Miller, the respondent number 3 and 4, Miller, they are still holding the post, Miller. They are enjoying the benefits, Miller, in spite of the order of this on the last 10 years, Miller. They filed a review, Miller, that was dismissed. They filed an appeal, that was dismissed, Miller.
Respondent 3 and 4.
3 and 4, Miller. They're the beneficiaries, Miller.
Who are they?
They were the teachers, Miller, who were illegally appointed, Miller. And their appointments were directed to be set aside, Miller. In fact, they were set aside by this honorable court, Miller. The appointments of respondent number 8 and 9 are hereby quashed. The respondent number 5 to 7 are accordingly directed to reinstate both the petitioners to the post of assistant teacher in the so-and-so school within a period of 1 month from the receipt of this order. But thereafter, they filed a review that was dismissed. Then they went on appeal, my lord. The appeal was dismissed on the ground of limitation, my lord. It was that was in 2021, my lord.
Let us see the order which is not complied with.
My lord, page 13, my lord. It's
begins from page 8 or what?
pardon, my lord?
It starts from which page?
Page 13, my lord.
13.
13, my lord.
Order dated
Order dated
9/4/14.
9/4, my lord. Yes, ma'am. Heard so and so. Then the petition is directed in the decision of the respondent 5, 6, and 7 in discharging the 2 petitioners from the respective posts of assistant teachers on certain such date in terms of the resolutions passed by the school managing committee purported on wheel of the villages and by replacing with the respondent number 8 and 9 who was stated to be working since 3/1/2009 and
Okay,
4/1/2009 respectively.
come to page 14.
Yes, my lord. Page 14.
Last paragraph.
Last, my lord. Resultantly, this petition succeeds. The appointments of the respondent number 8 and 9 are hereby quashed. The respondent number 5 to 7 are accordingly directed to reinstate both the petitioners to the post of assistant teacher in the so-and-so school within a period of 1 month from the date of receipt of this order. As the petitioners have been illegally and arbitrarily discharged from their respective posts, they are entitled to full back wages, which are also to be paid for the said respondents with the said period.
Okay, who are this respondent number 5 to 7?
5 to 7 were basically the education department officials.
But in this writ petition, I mean, in this contempt petition, you have made the teachers a party.
Yes, my lord. The teachers
Why?
were party, my lord.
Why?
Because, my lord, they were the person who were enjoying the benefits, so therefore they have to be defined.
No.
We sought setting aside of their appointment.
Their orders, their appointments have been set aside.
Aside, but they're still working, my lord.
No.
5 is below the deputy inspector of school.
See.
My lord, school, my lord, secretary.
8 and 9 are set aside.
My lord.
You have named so many people here.
8 and 9, my lord, my lord.
Who are the teachers here? 8 and 9.
Sangma and Bajendra Sangma, my lord, teachers, my lord. That, my lord, they are the content in the contempt petition, my lord, they are the respondents number.
What are their names?
My lord,
Premila Sangma.
Sangma and Bojendra Sangma.
Premila Sangma.
My lord. Premila Sangma is respondent number 4, my lord. Bojendra Sangma to good. Sure.
The other Sangma is not there.
Others Sangma might have retired before that, but that's the reason why I just going to find out.
So why have you made so many of them a party? Former president, former secretary. But Kremila Sangma.
Kremila Sangma. Responder 4, she was appearing, my lord.
No, Kremila Sangma is the secretary.
She was also the teacher, my lord. She became a secretary later on, my lord. She was also the teacher, my lord. The lordship sees, my lord, page 7, my lord. Then the parties' names are there.
No, who is this 5, 6, and 7?
5, 6, and 7 are the school authorities, my lord.
That is all required. You don't have to make everyone a party. 5, 6, and 7 could have been a party, that's all.
That
Because the direction was to them only.
That shows to them, my lord, and this person's appointments were set aside. So it was required that, my lord, we should have been reinstated in their posts.
So action has to be taken by 5 to 7. Who
5
are
to
they? Can you point out? Respondent numbers 5 to 7.
Yes, my lord. Now, what has happened, that's therefore, my lord, lordship will see, my lord, respondent number 3 is the former president, my lord. Then
No, I want to know who is respondent number 5 to 7. That's all.
5, my lord, is the school, my lord, represented by secretary, president of the managing committee. Page 7, my lord, page 7.
Page 7.
Yes, ma'am. The Angolguri Garo Medium LP School represented by the secretary, president of the managing committee of the school, so and so.
4733.
Then, my lord, 6, the president of the school, and 7 is the secretary of the school.
Okay.
Now, this Kremila Sangma, my lord, she was also the, my lord, one of the teacher. She became the secretary of the school. Respond number 4.
That's why you made a party.
That's why she had made a party.
Then secretary, president of the managing committee.
Secretary, my lord, president, my lord, Berlin Mumin and Piston Marak were there at that point of time, my lord, because that's why they were made parties, my lord. And then, my lord, respond number 5 is, my lord, the president who was there at the time of filing the contempt petition.
No, just a minute. We'll go one by one. Number 5, R5 is.
R5 would be, my lord.
Angol
3 and, my lord, 5.
Huh?
3 was the former president, my lord. And then subsequent president was respond number 5, my lord.
Bukerson Marak.
Yes, my lord. Bukerson Marak. And the former president was, my lord, when the order was passed, it was Mr. Piston Marak, my lord. Sorry, Berlin Mumin. Serial number 3.
So later on, you implemented this Bukerson Marak.
No, they were implemented at the initial statement.
Then how do you implement them together?
Because, my lord, when the order was passed, my lord, by the
President and former president.
my lord,
How do you implement both the president, former
because
president?
both of them were responsible because once the order was passed, my lord, by the time the contempt petition was filed, the incumbent changed. So both of them had a responsibility to, my lord, pass the order, my lord, take the necessary action.
When the order was passed, who was there as a president?
Order was passed, my lord, according to our information, Mr. Marak was the, my lord, president. The second, sorry, my lord, Mumin was the president, my lord.
Then when contempt was filed?
Contempt was filed, my lord.
Bukerson Marak became the president.
My lord, that, of course, date has, it was filed, my lord, in 2000, my lord, October 2014, after about 6 months, my lord. Order was passed on 9/4/14, and this was filed, my lord, on 2010/2014, my lord, contempt petition.
Now, president of the school? Who is that?
Mr. Bukerson Marak, my lord, 5.
Again, the same person.
Same person. Then, my lord, earlier secretary, my lord, was Mr. Piniston Marak, serial number 2. Who was replaced by, my lord, Kremila Sangma, who was the actually beneficiary teacher, my lord.
So tell me who are important here?
All are important, my lord. So if respondent number 4 is called, my lord, then everything will, my lord, be settled, my lord. This is the person who is now creating the problem, my lord, because she is now the secretary of the school and she is, my lord, holding on to the post, my lord.
Ramila Sangma.
Yes, my lord. And she was appearing in this case, my lord. Then she stopped appearing in this case now. After the last few occasions, she has not appeared.
Who is the council representing?
Mr. B. Chaudhary was representing her, my lord. The cause list shows, my lord, the name of B. Chaudhary.
First his name is there?
Yes, the name is there now.
Please write down. By filing this contempt petition, the petitioners, more than one petitioner, isn't it?
Two petitioners, man.
Why two petitioners? Two posts.
Two posts with them, man.
The petitioners alleged willful and deliberate violation of the court's order dated 9/4/2014, passed in WTC number 4733 of 2011, bracket annexure A. Stop. It may be seen that by the said order, the appointment of the private respondent numbers 8 and 9 were quashed, and the respondent numbers 5 to 7 in the writ petition were directed to instate the petitioners the post of assistant teacher in Angolpuri Garo Medium LP School within a period of 1 month from the date of receipt of the order. Now, according to the petitioners, despite serving a copy of the order to the respondents, the order of the court has not been complied with. This is item number. Although Mr. M. Datta, learned counsel for the petitioner, is present, no one appears for the respondents. Stop. The cost list shows the name of Mr. P.P. Barua, Mr. B. Chaudhary as counsel for respondent number 4, and also the name of Mr. R. Mazum,
My lord,
name of Mr. K.K. Datta.
R. Muzumdar is, my lord, side, man.
Yes, yes. K.K. Datta. Who's K.K. Datta?
KK Datta, my lord, I think Kishore Datta, if I'm not wrong.
In the cost list. Any show cause reply filed?
No, my lord. No, nothing was filed. No affidavit has been filed.
Although the contempt petition was filed as far back as in 2014, no show cause reply has been filed by the respondents. Full stop. Office note. Dated you cancel. Office notes. Yes, office notes shows that neither AD card nor unserved notice has been received back from the respondent numbers 7 and 8. Stop, Mr. M. Datta, learned counsel for the petitioner submits that the main respondents are the respondent numbers. Who are the main respondents?
4 and 5 would be, since they are the present, my lord, holding the post, my lord.
Their names are Sangma and Marak.
Yes, madam.
Submits that respondents number 4 and 5 are the main respondents. Who in fact are holding the post
My lord, secretary and my lord, president of the school, madam.
of secretary and
President of the school.
president of the school concerned.
And my lord, the respondent number 4 is the person, my lord, who was directed to be, my lord, whose appointment was set aside. She later on became the secretary of the school.
He also submits that, in fact, the appointment of respondent number 4
Yes, madam.
as teacher of the school was set aside by this court. And she later on became the secretary of the school. What should be done? You post it again some other day, or
Lordship will direct, my lord, either, my lord, direct their presence, my lord. Let her be present, my lord. It is a respondent number 4 should be present, my lord. Only then things will proceed. Otherwise, my lord, this has been, my lord, more than 12 years now, my lord, almost.
no, they have a council, that is why.
That's true, my lord, but then the one has been appearing the last few occasions, my lord. So let them, my lord, appear, my lord, in person, my lord. Let her come in person, my lord, things will be settled, my lord. Because she is, my lord, she is now the teacher, the headmaster, my lord, and the secretary of the school. And in spite of her appointment being set aside, my lord. Utter content, my lord, of this order on the court, my lord. 12 years, my lord, they have enjoyed the benefits, madam. While filing the appeal, there was a delay of about 1400 days, my lord, which was, my lord,
Which
the-
appeal? Which appeal?
They had filed an appeal,
Which appeal?
writ appeal. That was also dismissed on the ground of delay, my lord. They initially filed a review, then, my lord, a writ appeal. All these were dismissed.
Okay, that word for line, Mr. M. Datta, learned counsel for the petitioner submits that. In fact, the respondents concerned had filed a review as well as a writ appeal
Appeal, madam.
against the order dated 9/4/2014,
14, madam.
passed in WPC number 4733 of 2011. But they were both dismissed. This is in respect of writ appeal.
Appeal, my lord. The review order is reflected in the appeal itself, my lord. The review was, my lord, review petition number 21/15. It was dismissed, my lord, on 18/11/2016.
Dismissed on 18/1.
11.
18/11.
18/11.
2016
16.
and
The writ appeal, my lord.
17/12/2021 respectively.
Respectively.
So the names given here, spellings are different.
My lord, Gojendro, my lord, no, my lord, appeal was.
Cremila also,
Yes.
one is K, one is.
She wrote K, my lord, but she's the same person. Otherwise, she would have filed the appeal, my lord. The appeal was filed with the beneficiaries. They challenged that one.
Mr. B. Chaudhary is there, isn't it? He's the,
Mr. Bikram Chaudhary, my lord.
he's the standing counsel for,
Yes, he's also he was also the standing. In this
Which is-
case, he was appearing for the contempt.
B. Chaudhary is standing counsel for BTC.
Now. But here he was appearing on the basis of power given by respondent 4.
No, I understand. This is a contempt.
Yeah.
Definitely he has to file power. We'll give him one more chance to appear. We'll list it, and if doesn't come, we'll summon the other parties.
Then in that case, Lordship will issue warrant, my lord. Otherwise, Lordship will give them another chance. But otherwise, Lordship will issue warrant because they're playing with the court, my lord. 14 years, 12 years, my lord, she has been enjoying the order, my lord. She's become the secretary, my lord, now ruling the school, my lord. Enjoying the salaries, my lord, at the cost of the, my lord, the petitioners here, my lord.
Right, like this, since the counsel for the respondent number 4, who's counsels, yes, counsels for the respondent number 4, whose names are reflected in the cost list are have not appeared today. Let the matter be listed again on so and so to enable them to appear. Failing which, court may consider passing appropriate orders to secure the presence of the respondents concerned. All right. You can inform them they are your colleague.
My lord,
Oh, he's here.
Lordship, they are not in contact with me since long, Lordship. And whatever I could make it out, Lordship, one writ appeal was also filed by.
Dismissed.
That was dismissed. That I don't.
Can you contact them?
I will try.
We're having it on 30th again.
Yes.
Right, next line. Later on, Mr. B. Chaudhary, learned counsel for respondent number 4, appears and submits that he is not in contact with the respondents concerned for a long time and submits that he will make an effort to contact them and make his submission by the next date. List accordingly.
My lord has reflected the name of Mr. R. Muzumdar. That may be deleted. My lord he has become, my lord.
I have not reflected. You have you reflected? Not reflected. I have not reflected. That much I know.
No, the other person, the lordship might confuse the person. No, that's what I'm saying.
But Mr. Chaudhary, you impress upon your clients.
Yes, ma'am. The status of the Lordship that writ petition along with the contempt.
Because they know.
Yes.
If they are silent for a long time, I understand, but they know because they file review, they file appeal also. They know they're trying their best to, but they could not succeed. So there's no other way now.
Yes, Lordship. Okay,
If the orders are not complied with, we will have to.
I will impress upon them.
Well, if they are not contacting my learned friend, my lord, then that means they are not taking it very lightly, my lord. If they are not contacting my learned friend, they are not taking this seriously, man. So,
you contact them, call them, and tell them this is the things.
Yes,
position. And if they don't do that, we'll summon them. Yes.
Oblige, your lordship.
Lordship, can it be on 4th? Then I will have some time.
Surely, 4th.
Well, let me 4th. No issue. 4th. No issue.
Item 44.
May I please, Lordship? So last order, Lordship, I was directed to take steps upon sole respondent, my lord. I have taken step only register post, my lord. Two process, that is usual process and my lord, justice service, I will take, my lord. Within 1 week, I will take the justice service and usual.
You were asked to take steps in what manner?
3 ways, my lord.
3 ways.
Register post, usual process and justice, my lord.
And what have you done now? Registered post you've
Register
done?
post I have taken, my lord. Now, usual process and justice I will take, my lord.
White order dated 3/12/2025. Petitioner was asked to take steps for service of notice upon the sole respondent by speed post, by usual process, and also by way of Dasti. The learned counsel for the petitioner submits that he has taken steps by way of speed post and not by the other two means. He submits that he may be given some time to do the needful. In view of above. Father, how much time?
1 week, my lord. Within 1 week, I will take.
Huh?
Within 1 week, I will take.
7 days time is given to the petitioner to take steps by way of Dasti as well as by usual process. But in the meantime, registry shall track the postal consignment of the notice sent to the sole respondent by speed post on 8/12/2025 and put up a note.
All right.
This again on so and so.
41.
Lordship, the petitioner is not yet appeared, Lordship. Lordship, the stay is over for respond number 7, Lordship. This matter may be fixed for admission. Lordship.
You're for the department?
Lordship.
Five and 7 steps. Seven. What is the matter about?
Lordship.
What is the matter about?
Lordship, provincialization of the headmaster, Lordship.
And who are this respondent number 7?
Lordship, the headmaster, Lordship. The present headmaster, Lordship.
Headmaster. Any other private respond? Any
No,
private?
Lordship. Only respond number 7, Lordship. The headmaster who is currently. Yes.
You can appear for inspector of schools.
Lordship.
Demaji.
Lordship.
Headmaster is
Respond number 7, Lordship.
Karpumpuli High School, Jonai. See, the thing is that the petitioner seems to be not interested. Mrs. A. Bujar Barua. She's the appointed counsel.
Sure.
What to do? What is your prayer?
Lordship.
You have filed your affidavit?
No, Lordship, not yet, Lordship, because the is not yet complete, Lordship.
No, don't worry about that. You file your affidavit.
Lordship, we'll file it, Lordship, in the meantime.
To complete notice and Dasti is up to the petitioner. It's the lookout of the petitioner. On your part, whatever from, you have to reply from the department, you take care of that. None appears for the petitioner when the matter is called. Now, multiple orders have been passed by the Lavazima Court requiring the petitioner to take steps for service of notice upon respondent number 7. But despite the same, no steps have been taken by the petitioner. Stop. On 16/12/2025, counsel for the petitioner had sought for adjournment, and accordingly the case was adjourned without any mention about steps not having been taken on respondent number 7. Stop. It is therefore provided herein that the petitioner shall take steps to serve notice upon on respondent number 7 by speed post within 1 week from today. Failing which, court may pass appropriate orders which may be detrimental to the petitioner. Next para, Miss R. Barua, learned standing counsel, secondary education, appears for the State Department and seeks for 3 weeks time to receive instructions and to file counter affidavit, whereas allowed. List again on so and so. 25.
42 and 43.
Wait, Mr. Lordship.
Yes.
The item 42 is a review petition preferred by the state.
Okay,
We're
and
seeking review of an order passed in the year 2010, my lord.
it's related with that contempt also.
Yes, madam.
Related.
Yes, madam.
Where is the order?
Order, my lord, will find it page 10.
Dated?
Order dated 22/6/2010.
Yes. What is there you want to review?
This is regarding, my lord, the writ petitioners, they are basically illegal appointees of Dhemaji district, my lord. Earlier, they were terminated in the year 1992, but somehow they were continuing, my lord. And in 2007, we stopped their salary. Then they preferred a writ petition, and that writ petition was disposed of, directing to place their case before a committee, my lord. That order, my lord, will find at page 21.
No, before that, let us see the order itself, which you want to.
Yes, madam.
You're seeking review.
May I read, my lord?
Yes.
Heard so and so, so and so, so and so. It is stated at the bar by the learned counsel appearing for the parties that the issue involved in the writ petition is exactly similar to that of WPC number 1293 of 2008, which was disposed of by this court by order dated 19/6/2008. While disposing the writ petition, this court issued direction as follows. In the above factual premise, there is no other alternative but to conclude that the petitioners, in terms of the directions contained in the order dated 14/11/1995, passed in so and so, if as on date are rendering services to the department, are entitled to their salary. In other words, if the petitioners are in service, their salary in arrears from September 2007 is payable to them, ordered accordingly. As the learned standing counsel, education department has apprised this court that an exhaustive inquiry is in progress to identify the illegal appointments in the subdivision involved, and that the names of the petitioner are enlisted amongst those said to be illegally appointed. It is made clear that if, on completion of the investigation now underway, appointments of the petitioner are found to be illegal, as claimed by the departmental authorities, it would be open for them to approach this court for appropriate modification of this order, as would be called for in the facts and circumstances of the case. Since disposed of the above comes no cost. In view of the above, this writ petition is disposed of with the directions that.
No, just a minute. What is that? This part?
Sorry,
No.
my lord.
The petitioner stands disposed in above terms, no cost.
Yes, madam.
This is an abstract of the earlier order.
Yes. It seems, madam.
Hmm?
Madam,
Is it an abstract of earlier order? Yes. Up till when? Up till which part?
Because, my lord,
Up till no cost.
no cost.
Okay, then.
Then in view of the above, this writ petition is disposed of with the direction that the petitioners as well as the respondents authorities shall be bound by the direction issued in WPC number 1293 of 2008. The respondents authorities shall deal the grievances of the petitioners as per the direction contained in so and so, and pay the amount to the petitioner to which they are entitled. The state authorities are directed to release the salary of the petitioner which has been withheld from September 2007 and thereafter to pay them their regular monthly salary. So basically, direction was issued to pay the salary, my lord.
Service to the department are entitled to say, in other words, so you have to determine only whether it's payable or not, that's all. What
But-
is there to review?
But
If
in
you
page
say that
11,
the-
my lord, the page 11, the direction is,
No, if you say the appointment itself is illegal, then what is there to review? You can examine and say that appointment is legal, they're not entitled to any salary.
in fact, my lord, subsequently, screening committee was constituted in the year 2012. This order is of 2010. But before that, my lord, they have approached this honorable court and they got an order to examine their case through a committee, my lord. That order was suppressed while preparing this writ petition. That is why we prepared this review, my lord.
Which order?
My lord will find at page 21. My lord, kindly come to page 15 first. Page 15. Then my lord will find the name of the petitioner, my lord.
What is 15? Beginning
Page
of 15?
Area of parties, my lord.
No, 15 is a part of what? Of the order?
Yes, my lord. Page 15, last petitioner, page 2. It's a part of orders. Starts with page 12, my lord.
Order passed in which case?
1634/2007, page 12. My lord will find that
Whose writ petition was this?
this writ petition filed by the petitioner along with some other similarly situated person, my lord. 1634 of 2007. My lord will find the name of the petitioner at page 15 and 16, my lord. Serial number 25, Zoya Hazarika, then 26, Renu Coach, and 27, Boykuntha Coach. These are the petitioners involved in this review.
How many writ petitions have they filed?
Earlier, they have approached my lord by filing this writ petition in 2007
And claiming
with the same relief, my lord.
same relief.
Yes,
Then
my lord.
what was the order?
Yes, my lord. My lord will find at page 21. Second paragraph, my lord. The petitioners are assistant teacher of LP school in the district of Dhemaji, Assam, and they have challenged this in this writ petition an order dated 9/2/2007 issued by the government and the order dated 17/3/2007 issued by the district elementary education officer Dhemaji, whereby it has been directed that petitioners should be treated to have not been in service since termination of their services with effect from 18/5/1992. The petitioner contends that they were never served with any order of termination of their service. The respondents on the either hand contend that in Dhemaji district, teachers were appointed against non-section post, and because of this reason, the department concerned had to make inquiry into such illegal appointment and issue consequential order of termination. In these circumstances, the respondents contend that the petitioners are not entitled to payment of their dues. For the purpose of determining entitlement of the petitioners, such as the present petitioners, a committee has already been constituted by order dated 22/8/2006, issued by the government of Assam Education Elementary Department in terms of the direction given by the judgment and order dated so and so. The judgment and order dated so and so. The terms of reference of the committee as follows. Then my lord will page 22. Serial number 1. That at one particular point of time, large-scale anomalies had occurred in the matter of appointment of school teachers who was appointed against non-existence and fictitious posts, and in some cases, even appointments ordered with fake and manufactured documents. The dispute raised earlier bunch of cases as referred by the Honorable High Court in so and so, and in present bunch of cases would not only require determination as to the validity of the appointments made, but a further exercise is required to find out as to whether, notwithstanding the illegalities in the appointment, the persons concerned had rendered services so as to decide their entitlement to salary, at least for the period of which services was rendered. The exercise which will have to be taken would essentially be a fact of finding exercise, and the core facts which would be necessary to decide the dispute and the consequential entitlement of the parties may require giving an opportunity of hearing also. The committee will determine the reasons for non-payment of salaries stipend to each of the petitioners in the present group of cases, and in that regard, if required, may also determine the validity of the appointment of the petitioners. The committee, irrespective of the question of validity of the appointment of the petitioners, shall ascertain the period for which the petitioners had rendered services in the post to which they were appointed, if any. The committee will hold its deliberations from time to time at such period intervals as may be considered appropriate. The committee will also take up the cases of such other petitioners which may be referred to it by this court in the future. Though no specific time schedule is fixed, the committee will undoubtedly hold its deliberations and render its decision expeditiously and will submit its finding to the state government for consequential action from time to time. The finding of the committee will be implemented by the state government in the education department by taking such further action as may be required. In the event the appointment may be of any of the petitioners is found to be illegal, the state government, if so advised, may proceed against such illegal appointees in accordance with law. The terms of reference as quoted herein are applicable to a case of the present nature too. This position, however, could not be assailed by the petitioners. In view of the above, with the direction to the respondent concerned to submit the cases of the petitioners to the state committee for its examination and proper decision. The whole exercise so directed shall be completed within a period of 6 months from today. If the petitioner feel aggrieved by the decision which may be reached by the committee, the petitioner shall be at liberty to the course to such provision as of law as may be permissible. With the above observation and direction, this petition shall be disposed of. So, they have earlier they have approached this honorable court challenging the non-payment of salary, stoppage of salary. Then this order was passed. Subsequently, when they have again approached in the year 2007 itself, 2008, and they got an order whereby direction was issued to release their salary,
There was a case referred to in that case.
Yes, my lord.
WPC 1293.
1293. In that case, there was a direction to release the salary if they are working. And on the basis of that order, they obtained this order, without disclosing the fact that they have approached with the same cause of action. On that ground, this review has been filed. And in fact, subsequently, in the year 2012, a screening committee was constituted. Their entitlement was decided,
What was the direction in 1293?
1293 direction is quoted here in the third paragraph,
Just read once again, fourth paragraph.
Yes, from the
As the learned standing council.
As the learned standing council, education department has apprised this court that an exhaustive inquiry is in progress to identify the illegal appointments in the subdivision involved, and that the names of the petitioners are enlisted amongst those said to be illegally appointed. It is made clear that if on completion of the investigation now underway, appointments of the petitioner are found to be illegal as claimed by the department authorities, it would be open to them to approach this court for appropriate modification of this order as would be called for in the facts and circumstances of the case. The petition is disposed of in the above terms, no cost.
So what does it mean? I fail to understand this.
That in case of if they are found to be illegally appointed, then the department is at liberty to modification of this order, to approach this honorable court for modification of this order. Because essentially there is a direction to release the salary.
If as on the date of rendering service, department are entitled to the salary, in other words, no.
In the last paragraph, my lord will find there is a direction to release the salary, my lord.
They are entitled to the salary. In other words, if the petitioners are in service, their salary and arrears in September is payable to them accordingly, ordered accordingly. So court found that they are entitled to arrears salaries.
Yes, madam.
But then court also took into consideration the fact that there was some inquiry.
Yes, madam.
If upon such inquiry conclusion, if the appointment was found to be illegal, then department could approach the court for modification.
Liberty was given us to approach this honorable court for modification of the order, but especially direction.
Did you go for a modification then?
That
because today you are saying it's illegal appointment.
Yes, my lord. That is why we prepared this review
and
for modification of this order, my lord.
And this order and this writ petition 4082 says that it is also covered by the earlier order, 1293.
Yes, my lord.
So same order. And today you are here in review.
Yes. Because they have earlier approached this honorable court.
Where is your ground? Let us see.
But
Where have you
while,
stated?
while preferring the review petition, my lord, no specific ground was asked as we do in the review petition, my lord. They have just narrated the
Then-
facts, and that will, my lord, will find in paragraph 4.
Then what is there to review then? Para number?
Paragraph 4, my lord will find. 4, 5, 4, 5, 6, and 7, my lord.
Is there anything at all to review? You have not taken any specific ground also.
Yes, my lord. While drafting the review petition, my lord, grounds were missing, but in the
Oh, but then show
factual
me,
narration that has been mentioned, my lord, but
grounds have not been mentioned, but show me the documents, annexures.
that is the document, my lord, they in 2000,
Which document?
this order, my lord.
The order is,
Order I have
there is an
referred,
order, that's all.
that order regarding the filing of the earlier writ petition, that
No.
was,
You cannot just rely upon this order like that. Court has given you liberty to approach for modification.
that is why, my lord,
And if you find that their appointment is illegal, and court has also taken to the consideration the fact that some committee was formed.
yes. In fact, my lord,
So you show me the committee, finding of the committee that something was there.
that I can bring it on record by way of an additional affidavit, because, my lord, that was after filing of this writ petition.
Why
that,
should we permit you to do that?
only
This is
difficulty, my
not
lord,
yesterday that you have filed this review.
this
This review was
petition-
filed in the year 2017,
2017, but the
and it has been lingering like that.
report of the committee was ultimately filed on in 2020, my lord. Screening committee was constituted. That committee gave a report in the year 2018, and decision was taken in the year 2020 after filing of this review petition, my lord. And most of the illegal appointees who were appointed during that period, they have been given a fresh accommodation, my lord, subject to their education qualification, my lord.
See, you say there's no documents give the next year.
Document, my lord, only the order.
There's nothing.
Only the order.
There's
my
no
lord.
grounds, there's no document except for the court's order.
Yes, my lord.
So on that basis, how do you intend to convince the court that a ground for review is available?
Because, my lord, while they have preferred the writ petition in the year 2008, they have suppressed that they have filed a writ petition with the same cause of action in the year 2007. They got an order that was suppressed in the subsequent writ petition, my lord.
So that
And they
earlier order, how does it affect you?
Because in the earlier order, my lord, there was a terms of reference. And according to that, my lord, there is no direction to make the payment. But in the subsequent order, though liberty was granted to the government to prepare an application for modification of the order if they found illegal, but essentially there was a direction to make the payment. But in the 2007 writ petition,
see,
that order was not there, my lord.
They may have suppressed it, as you said it, but the thing is that suppress has not, whatever suppression they have made does not actually affect you, because what order was passed by the previous court was that there was some committee constituted to find out
Yes.
about their status of their appointment. That's all. And in the second writ petition, they say that some area is pending.
Yes, that
And
is
that
my
area itself is also not conclusive. It says that if there's something wrong with the appointment, if it's illegal appointment, then you come again before the court seeking modification.
Kindly come to
That we have not
last
done.
paragraph, my lord, last paragraph, last two paragraph, my lord.
Of
Page 10 and page 11. May I read, my lord? Page
10
10 and page 11.
10 and 11, what is that?
The order under review, my lord. In view of the above, this writ petition is disposed of with the direction that the petitioners as well as the responding authorities shall be bound by the direction issued in WPC number so and so. The responding authority shall deal with the grievances of the petitioner as per the direction contained in so and pay the amount to the petitioner to which they are entitled. Next page, my lord. The state authorities are directed to release the salary of the petitioners which has been withheld from September 2007 and thereafter to pay them their regular monthly salary. So essentially, there was a mandamus to pay their salary, my lord.
No, this was subject to the direction given in that WPC number 1293. Because the writ petition this writ petition 4082
yes
of 2008 and the order which was passed, which you seek for review, has not been decided on its own merit. It has been decided
yes, my lord.
in line with the earlier writ petition.
But still, my lord.
So that's why court has said this writ petition is disposed of with the direction that the petitions as well as the respondents shall be bound by the directions
yes
issued in WPC number 1293 of 2008.
But
so what is there in 1229 2008? You can see already in paragraph number, third paragraph and fourth paragraph.
Yes. But
So much liberty is given to you.
Liberty, that is why, my lord, since there is a liberty in 1293, there was a liberty given to us, my lord, to prefer a application for modification.
That liberty is also available in this because you are bound by that order, it says.
That is why, my lord, since subsequently there was a screening committee and the screening committee, there was a finding of the screening committee.
So what
That
is the
why-
finding of the screening committee?
That, my lord, since finding was given after 2017, so that I have to bring into record by way of an additional affidavit, my lord. Because that finding was given in the year 2020, my lord.
2020, now it's 2026.
Yes, my lord.
After 6 years, 5 years, you want to come and bring that thing on record. Review petition filed in 2017.
17, my lord.
You have not pursued the review petition. Similarly, respondent also has not pressed for disposal.
Because, my lord, subsequently, my lord,
It's just lingering like that.
in fact, after the decision of the screening committee, most of the illegal appointees of Hemazi and Lakhimpur district, they have been given fresh appointment. That is why, my lord, the petitioners are also, my lord, not pursuing. My lord, may give me one chance so that the fate of their screening, that I can bring it on record, my lord.
And contempt is there pending along with this. You are appearing the contempt petition also.
Yes.
You are appearing in the contempt also.
No, my lord.
Respondent. Who's appearing for the respondent in contempt? R.M. Deka, N. Sharma, D. Setia.
My lord, in contempt, my lord, the contempt, first contender number 1 is no longer holding the office, my lord. And the contender number 2 director, he expired, my lord.
Who expired?
Contender number 2, the earlier director of elementary education.
Okay. Okay, what do you want to produce in the review petition?
Sorry, my lord.
You wanted to produce something in the review petition?
Yes, my lord.
What?
My lord, 2012, a screening committee was constituted to verify the legality of those appointees, my lord. So ultimately, that screening committee took a decision to file the report in the year 2018, and subsequently cabinet took a decision in the year 2020. So that I want to bring it on record, my lord, because earlier also direction was issued to verify their
Okay,
service status.
you'll give one chance. Mr. N.J. Katania, learned counsel for the review petitioner submits that he may be permitted to file an additional affidavit to bring on record the
Status of verification of the
status of verification of the appointment of the
writ petitioners.
writ petitioners of the
Respondent.
respondents. As determined by the, what committee you say?
Screening committee, my lord.
That's determined by the screening committee. And for which he prays for 2 weeks?
Yes.
2 weeks' time. Praise aloud. Next para. In respect of the contempt petition, it is submitted to the bar. The respondent number 1 is no longer holding the post, and respondent number 2 has expired. Such being the case, the counsel for the petitioner, Mr. R. Sharma, submits that he will take appropriate steps to impede the present incumbents and prays for 2 weeks' time as well. Praise aloud. List again on soils.
Wait, Your Lordship. Lordship, we were directed to file an affidavit in this matter, Lordship, but we have received our instruction last evening, Lordship. Lordship, we'd like to file next week, Lordship. Next Wednesday, Lordship. Due to paucity of time, we could not file it, Lordship.
You have received the vetted affidavit.
No, Lordship, I have received the instructions last evening, Lordship.
Okay. So what do you want to do? You want to file an affidavit?
Yes, Lordship. Next Wednesday, Lordship.
You'll file it by next Wednesday.
Lordship.
Ms. R. Barwa, learned study counsel, Secondary Education Department, submits that she has just received instructions in the matter from the department and prays for a week's time to file the same by way of an affidavit. Praise aloud. List again on.
Impleadment.
45.
45 Lorships may look into this in the last total of 10, 12, 25. 10, 12, 25. My lord, this is order, Lordship will find it page 15, my. And the relevant paragraphs at page, my lord, 25 of the contempt petition, my lord. Lordship kindly see. And vis-a-vis their conduct.
No, just a minute.
Paragraph 25, 26, 27.
What are you saying? Which paragraph of what?
My lord, the direction of this honorable court.
Page number?
Page number, my lord, page 25, paragraph 25, 26 and 27.
Okay.
Would challenge the provincialization respondent number 6. This provincialization was set aside and interfere with, and our case was directed to be considered by this committee, and entire matter has to be done within a period of 3 months from the date of certified.
Yes, last time they said the matter has gone to finance.
Yes, Malay, we have forwarded to but finance has returned. Malay, asking matter, we have to submit the phrase proposal along with checklist.
Why?
Financial and which also has to produce the appointment letter also. Kindly see my communication first paragraph.
On 21/2026, my lord, department has asked the district director elementary education to provide the checklist and financial implication and the
Court
SLC
has settled everything.
True, that is true.
This honorable court has settled everything. Respondent 6 appointment was set aside.
Yeah, kindly see, my lord. In this connection, I would like to resubmit the proposal along the checklist and financial implication and SLSC minus dated 23/6/2025. Well, here
This
we
is-
have submitted, man, on 20th.
Proposal is again resubmitted now
True, my lord.
on 20 January.
My lord. Finance is asking for this, but the checklist, financial implication and SLSC minus. That is why we submitted it.
And by where my left 2 years. Have already gone by from the finance department. Honorable court also granted the time with a specific direction to produce the appointment letter. 10, 12 or 25 order is quite clear. Not only this 10, 12 order, earlier order also my lord directed them to produce the appointment letter, complete all the process. Now whether they are going to this department, that is their internal matter.
That was the order dated 10/12/2025. Now, Mr. P.K. Bora, learned counsel appearing for the which respondent?
Sole respondent.
Sole respondent submits that some clarification have been sought by the finance department. And the Directorate of Elementary Education was asked to submit fresh proposal. You have another copy with you?
My lord.
You have another copy with you? One more copy?
Yes, I have.
Just read, just see the reference.
Reference, my lord, date is wrong, my lord. The government letter E dated 21/2025, it should have 2026, my lord. Kindly see, my lord. With reference to the subject cited, I would like to state that as per instruction of the government letter under reference dated, it should have, my lord, 2026, my lord.
Which one is wrong?
Well, reference, well. This 2025 should have 2026, man.
So,
How can, on 20.
suppose, do you mean to say that on the same date of
Only on 21/2026, my lord, they have asked that the director elementary education.
No, listen. As per the reference.
That letter also I have, my lord, that 21/2026 now.
How is it possible that on the same day you write back?
My lord.
Today they write letter and today itself you write back?
My lord, this is the communication they have, my lord, that the department.
Is it possible like that? Tell me.
To my understanding.
Are you sitting on the same room?
No, my lord.
Director and secretary?
Director, not so far from director in the Dispur and director in the Kahilipa and here, my lord, all these things.
That is why reference letter says 21/2025.
These are e-files, my lord.
Huh?
These are e-files. E-files.
Okay, e-files.
My lord.
So on the same day it's possible.
Maybe possible.
What is that letter you're showing me? Sorry.
This letter is issued to the director limited also, the secretary.
So on the same day, they have replied.
My lord.
Anyway, let me go and see.
And my lord, they are, my lord, that respondent also personally appeared and committed that he will issue the appointment letter by next day. Lordship may see earlier orders also.
Let us see, the direction was at page. What is the order?
My
Op-
lord,
operative portion?
10-11 orders.
Paragraph, operative portion of the order.
My lord, judgment of this honorable court.
Yes, yes.
Yes, my lord, it start from page 4.
No, no, operative portion.
Operating portion page, my lord, lordship will start from page 24, my lord.
How can the operative portion be 5-6 pages?
My lord, normally, I am
No,
not going to the factual metrics, my lord, of this case.
Then don't show me that.
Then turn that, my lord, page from 19, paragraph 19, lordship.
Operative portion. Do you understand the meaning of operative
Yes,
portion?
my lord. Operative portion, page 25, in view of the above position. Lordship, may kindly page 25 of the judgment. Page 25. In view of the position and the conclusion reached herein above with regard to the provincial service of the respondent number 6, herein such provincial service respondent is hereby interfered with, and accordingly the order dated so and so passed in this connection by the Director Elementary Education Department Assam is set aside. Next, my lord. Having set aside the order dated so and so issued toward the provincialization of service of the respondent number 6, the Director Elementary Education now directed to place the case of the petitioner before the state level committee by disclosing the actual and correct date of joining of the petitioner in his service as noticed herein above, and in this order here, and thereafter to have his case scrutinized strictly in accordance with the provision of the existing in the Assam Education and Provisional Service Teacher and so Act, and basing on the recommendation he would be made by the state level, it would be made by the state level committee to process the matter further for a provisional service of the petitioner herein. The next paragraph 27, the exercise is now required to be carried out in terms of the direction passed by this honorable court herein before shall be initiated and completed within a period of 3 months from the date of receipt of the certified copies of this order. Now, when this order was passed, my lord, this order was passed on.
Just a minute.
Yes.
Then what is this observation again regarding respondent number 6?
Now, the respondent number 6 shall also be permitted, Lordship Maker, to urge any further ground, page 20, para 28, the interference made by the court with the provincialization service of respondent number 6 for the region assigned herein before will not bar the respondent number 6 to approach the respondent authority by way of submitting a representation highlighting the stand as taken in the said respondent before this honorable court. The respondent number 6 shall also be permitted to urge any further grounds as may be available to her in event of such representation being filed by the representation number 6 before the respondent number 2, namely so and so, the same shall be given due consideration in according to the provision of the so and so act.
Okay.
Then para 30, my lord.
It's okay. Who's respondent number 6?
Respondent number 6 are private, whose hybrids are provincialized, my lord, by depriving me. His provincialization was challenged by me in this petition. His provincialization was set aside, but he's given a liberty to approach my.
Come to page 15.
Yes.
Respondent number 6 is headmaster.
Headmaster. No.
Headmaster. See. Page 15.
Number 6, yes.
What headmaster is agree with? He's not agree with anybody.
Here, my lord.
Anyway, I'm not on that. Mr. P.K. Bora,
My lord.
this letter, Department of, see, Finance Department has conveyed the following. Department of School Education, Elementary is advised to
Yes.
resubmit the proposal along with approval of the Honorable Chief Minister.
But that part I don't want to submit. Only remaining.
Why?
Remaining part, my lord.
Court order is not good enough.
My lord, here, kindly see, my lord, my instruction, my lord. Second page.
Huh?
Second page. Kindly see my instruction, my lord. Second page.
Page 14 of the petition is Aisha.
Second page, last para, my lord. Second
Diary
page,
of the
last.
respondent.
The report of the DE of Bongaigaon was placed before the joint committee meeting dated 4.
Where, from where reading?
My instruction, my lord.
Which
Not-
one?
Not that one, my lord.
Ah,
Earlier one, my lord.
the report.
The report of the DE district elementary. Education
Where,
Bongaigaon
from
was
where you reading?
Last para, my lord.
Last para.
My lord. Placed before the joint committee meeting held on
Yes.
12/22 for verification. The committee stated that the petitioner had been teaching social science while the respondent was 6.RB. The provincialization of service of order issued by this office dated 5/2/2021 in respect of Aisa Khatun has been set aside by the Honorable High Court. Vide order dated so and so. Passed in WBC number 2144 of 2021 and in compliance of the aforesaid order, DE Assam cancel the provincialization service of Aisa Khatun Vide order dated 10/1/2025. Also, the petitioner has fulfilled the eligibility criteria for provincialization of his service as per the Act of 2017. And upon cancellation of the provincial Aisa Khatun, there is no financial implication. So the committee decided that the government may take a decision on the matter for provincial service of the petitioner. Therefore, government is requested to necessary steps for provincial service of the petitioner. Shahjahan Ali against Bandardara Girls ME School, erstwhile ME Madrasa as tutor under Provincialization Act 2000 by creating a post under head of so and so on.
Everything is crystal clear.
In my understanding, but query put by the finance department has meet up more by this findings.
Finance Department is another party in the writ petition. They were not a party, isn't it?
No, because finance did not came at that, popped up at that point of time.
Luckily, they're not a party.
Yes.
Luckily,
Yeah.
we would have made them a party now. So,
Only direction are given to Director Elementary Education.
Mr. Bora,
Well, 2 weeks time maybe tratable in the meantime, I hope my process will be complete.
please write what did I say? Stop. Accordingly, no, not accordingly, cancel that. The same was conveyed. The observation of the finance department was conveyed to the Director of Elementary Education, Government of Assam, by the Deputy Secretary of the same department. White letter dated 21/2026. Stop. Mr. P.K. Bora, learned counsel submits that in response to the same, the Director of Elementary Education on the same day had submitted a reply with all particulars as was necessary to the Secretary to the Government of Assam, Elementary Education. Stop. He has produced the same copy of the same. He has produced a copy of the said letter, which is dated 21/2026. 20th of January 2026. 21/2026. Next, but it is noticed that several opportunities have been granted to the respondent to come up with the compliance report. Having regard to the fact that the order was passed by this court on 23/4/2024 in the writ petition. Stop. Next para, upon considering the materials available on record and submission made by the learned counsel for the respondent, one more opportunity is granted. Come up with the compliance report of the order of this court. How much time should be required?
2 weeks, man.
2 weeks. List again on so and so. Copy of the communications dated
Communication issued by the director may be kept on record, madam.
Huh?
Hopefully the communication issued by the director may be kept on record, madam.
I'll keep both the communications on record. Copy of the communications made by the Deputy Secretary, School Education Department, as well as the Director, School Education Department. As well as the Joint Director, Elementary Education Department. Both dated 21/2020 are kept on record and marked as X and Y for identification. What is the date?
Plus.
This was item 45.
Item number 23, 32 to 35 million, maybe listed in the first week of February. They file affidavit to them.
Which case?
Item number 32, 33, 34, 35. All are the similar matters. Admission matters. 32, 33, 34, 35.
Okay.
Regarding provision of service bill.
Fine, you'll get a date as per the convenience.
Any day in the first week of February.
We'll see our calendar of dates and we'll,
2nd February.
we'll get a date.
2nd February.
You give them the dates.
2nd February.
Give them the dates as per the convenience. Because we don't want to jumble up all the cases together in one day. There's one serious matter. Why? What is this? Serious matter. 54 to 85.
Serious matters.
53, my lord.
54 to 85. There's one serious matter.
53, your lordship, I'll pray to fix it after 10 days or so.
No, I said 54 to 85.
25.
54 to 85. There is one serious matter. Whose matter is that?
Yes, my lord, we have not served the copy. My lord, that the respondent had filed one. Series matter, my lord.
Series 54 to 85.
55, my lord. The one case they have filed affidavit and our matter is item 77. We have not received any copy, my lord. Affidavit in opposition.
Why is it listed today otherwise? It is under the admission column. Anyway,
Lordship, I pray for giving one date in item 46, contempt matter, your lordship.
you will get a date. Please have a word with my court master. She'll give you a date because we want to adjust accordingly. If there's any interim order, please indicate that.
My lord, in the series items, there are interim orders in some of them. My lord, in the series that you have mentioned in the supplementary list, there are interim orders in some of the items.
Obliged.